when it went in the Dropbox. Okay,
Thank you.
very
Uh,
well.
Second question. Uh, Gideon Elliott is another counsel for NMPRC Utility Division staff, and he will not be cross-examining witnesses, but he wants access to the live stream, this version, the Zoom stream, and I forwarded him the link. Is it okay for him to join that way?
I prefer that unless the parties are actually participating, that everybody else watch the YouTube, which actually is live now. So we are being live streamed. Is there some reason why Mr. Elliott can't watch on YouTube?
Um, Madam Hearing Examiner, no, he just wanted it to be at the same time, but you're saying it's live stream, so
It
that
is now. Yes, ma'am.
that takes care of that. Thank you.
Okay. All
That
right. Any other?
And one more question, I realized. So we, Katie Lang and I are representing utility division staff. Um, it, it's my understanding that as long as one of the co-counsel are uh, present and on screen, like our face during the hearing, that we don't both simultaneously need to be, because there are certain days where Miss Lang's witnesses will be, and certain days where my witnesses will be.
Yes, ma'am. That's fine.
Okay, that's it. Thank you.
Okay. Thank you. Any other procedural matters that we need to discuss? Again, anybody know who this 221540 is? Nope, nobody's claiming them. Okay. I've got a couple of issues. I'll just let you know. I will report them on the record. We need some corrections, Ms. Hardy, in your notice of filing of affidavits. Um, um, the procedural order in this case was issued on October 3rd. The affidavit references second procedure order issued May 6th. I don't believe that's correct. Nor does the affidavit filing include compliance with mailing to the post office or mailing to the public libraries as was required in the procedure order. That needs to be taken care of.
Okay, we can do that, Madam Examiner.
Mr. Harris, with regard to Ms. Glick's testimony, pursuant to the procedural rules that the commission utilizes, pages are supposed to be numbered. The line numbers are required to be put in the testimony. Ms. Glick's testimony does not comply. Please make sure that's taken care of before you offer her testimony.
Thank you, Madam Examiner. I will make sure that's taken care of.
Thank you. Also, Ms. Hardy, with regard to Mr. Cunningham's rebuttal testimony, it looks like to me when I went through that, and I went through it twice, so you can tell me if I'm wrong, but please check it. It looks like that once you get to page 24 of his rebuttal testimony, it repeats the page numbers at the bottom of the page.
Okay.
Start over again. So I'd like to see that fixed.
Okay.
Okay.
Madam Examiner,
Yes, ma'am.
I do know now that the number you were asking about on the Zoom is SPS's witness room.
Okay, is that different than, is that different than, like where Mr. Rodriguez is?
Yes, he is in a separate location, but our subsequent witnesses will be in the witness room with the number that you
Okay,
asked about.
all right. Well, if it comes back, I'll let it in.
Okay,
Uh,
thank
okay. Miss Lang,
Good
you had a
morning.
procedural question?
Yes, ma'am. Would it be possible for Miss Keppenbrook to resend the Dropbox links because the previous ones no longer are working? And I'm trying to upload the corrected staff testimony, please.
Okay,
Ms. Lang, this is hearing examiner Schaefer. I'm also having some trouble. I think it's a work firewall issue. So I'm going to try to contact Jude here because I'm also not able to log in. I was able to log in very briefly about an hour ago, but it hasn't been working since. So give me a minute to work on that and I'll update everybody on the progress.
Thank you, appreciate it.
okay. I see one other. Miss Miller?
Yes, good morning, Madam Hearing Examiner. I just sent everyone an email when I had uploaded LES's exhibit and exhibit list last Friday. Somehow the titles of those documents got changed, and I think it was our document system here at our firm. So I re-uploaded those this morning. Hopefully those will have the correct titles.
Okay. Thank you.
You're welcome.
Mr. Walker?
Thank you, Your Honor. And I'm also having a Dropbox problem. I tried to get on and it's telling me that a request was sent for approval and I never heard back. I'm kind of new to Dropbox and I don't want to slow down. Maybe somebody can help me separately, but I haven't been able to get in either.
Okay. We'll see what we can do, sir. Okay. So you need to drop your hands now. Miss Miller, Mr. Walker, there we go. All right. Very well. Mr. Lee.
I'm ready when you are, Judge.
All right. Miss Hearing Examiner Schaefer.
I don't see him on, Judge. Oh, there he is.
Hearing Examiner Schaefer.
Hearing examiner Hurst.
Okay, are you ready, sir?
Yes, I just have IT here to help me with the Dropbox,
Awesome.
but I'm here and paying close attention.
Very well.
Okay, thanks. Good morning, everybody.
Good morning, everyone. We are here today in case number 2500066 UT. This is in the matter of Southwestern Public Service Company's application requesting issuance of certificates of public convenience and necessity to construct, operate wind, solar, battery, and thermal generation projects and associated facilities. Issuance of certificates of public convenience and necessity, location approval, and right-of-way width approval for transmission lines. Authorization of related rate-making principles including accrual of an allowance for funds used during construction, variances on abandonment of toll generating station and Class 2 affiliate transactions, and other associated relief. This is the date, time, and place for hearings in these matters as set forth in the procedural order issued in this case on October 3rd, 2025, and in the order setting further procedural dates issued on December 29th, 2025. My name is Elizabeth Hurst. I am the designated hearing examiner along with my co-hearing examiner, Mr. Patrick Schaefer. Along with us today is our court reporter, Mr. Lee. Should anyone need anything to do with the transcript, you'll need to contact Mr. Lee directly. Along with us today, we have Chairman Aguilera and Commissioner O'Connell. I would like to get our appearances for the record in today's matter, beginning Ms. Hardy with SPS.
Good morning, hearing examiners, commissioners, and colleagues. Dana Hardy on behalf of Southwestern Public Service Company, and also appearing with me for SPS are Mr. Matthew Larson and Mr. Winston Skinner. And we do have a couple of other attorneys, Mr. Jared Jones and Mr. Sam Eisenberg, who will be appearing at various times during the hearing, but are not on the Zoom today.
Thank you. And I'm going to go by virtue of cross-examination order. So I believe that the next party, Mr. Stoffel.
Yes, good morning, hearing examiners, commissioners, parties. Nick Stoffel with the law firm of Holland and Hart, appearing on behalf of the New Mexico Large Customer Group. I'd also like to enter the appearance for my colleague, Austin Rushoff, who's here with us this morning.
Very well. Good morning. I believe our next party would be OPL.
Good morning, Your Honor. Michael McMillan for OPL, and I'd also like to make an appearance for Philip Oldham, who is not currently on the hearing but may join later in the proceeding.
Thank you. Good morning. LES, please.
Good morning. This is Joan Drake with the law firm of Modrell Sperling, appearing for Louisiana Energy Services, or LES. Also with me is my co-counsel, Susan Miller.
Good morning.
Good morning.
And I believe next would be Mr. Walker.
Yes, Your Honor. Mark Walker for Targa Resources. Thank you.
Thank you. Ms. Beatles?
Good morning, Sydney Beatles for Western Resource Advocates.
Good morning. Ms. Lynch, Mr. DeSalen?
Good morning, Carol Lynch for CCAE, here with Charles DeSalen as well.
Very well. And then Ms. Lynch for Prosperity Works?
I'm also here for Prosperity Works.
Very well. Good morning. Ms. Zur?
Good morning. I'm Stephanie Zur, and I am here on behalf of the Sierra Club. I'm joined by Kristen Henry, another attorney. Kristen is spelled Kristin.
Good morning. Thank you. Mr. Harris?
Yes, excuse me, Brian Harris, on behalf of the New Mexico Department of Justice, I'm joined by my colleague, Larry Marcus. And we will be covering this hearing, one or the other.
Okay, thank you. Good morning. And Miss Amer and Miss Lang?
Good morning, Madam Hearing Examiner. Katie Lang on behalf of staff. With me also is Miss Judith Amer, also representing staff. Thank you.
Thank
Hello.
you. Hi, Miss Amer. Good morning. Okay, I believe that we have our appearances on the record. I have a couple of procedural matters that I'd like to deal with before we begin the evidentiary portion of our hearing. Just first like to welcome everybody and let you know that the meeting is being live streamed. Therefore, any of your witnesses or co-counsel or whoever can watch the hearings via YouTube. One of the issues that I dealt with off the record, the affidavits of mailing, publication, and web publication filed by SPS in this case on the 28th of October indicate that the original notice was in fact mailed to SPS's customers / ratepayers. Notice was also placed as required on the Excel website. Further, also as required, the notice was required because of the right-of-way requests to the specific adjoining landowners. And this filing indicates that that was also done. Further, the affidavits also indicate that the notice was published both in the Albuquerque Journal and the Roswell Daily Record as required. At the pre-hearing last week, I believe that and Hearing Examiner Schaefer, that we dealt with some outstanding procedural issues. And I just want to clarify for the record that the staff motion to accept Mr. Zigich's testimony out of time was not opposed and is granted. Also, I want to note for the record that a protective order was issued in this case on the 8th of September, 8th of October of last year. And if there is any reference to testimony claimed to be confidential under that protective order, the witness or counsel for the witness will need to specify that as special protections would need to be taken, and the hearing would have to be closed for the duration of that that testimony and or reference. There were 4 public comments as of yesterday filed in this case. So I'd like to note for the record that there was a public comment by someone who identified themselves as Kaylin, and that's Kaylin, last name Rose. This person identified themselves as a SPS customer from Clovis. And the substance of her comment was that she wished more information regarding this case and clearer information. There was also a comment from someone who identified themselves as Thomas Stanley. And Mr. Stanley objects to the taking of land. There was another comment from someone who identified themselves as James Robertson from Roswell. And Mr. Robertson strongly objects to the requests in this case. And then finally, there was a public comment from someone who identified themselves as Kristen, Kristen, Gamboa, Gamboa. This person further identified themselves, I believe, as the executive director of the Carlsbad Department of Development. And the substance of this comment was that the Carlsbad Department of Development strongly supports the requests that were made in this case. That ends my review of the public comments that have been made in this case. I believe that the other thing I wanted to say before we got started today, I think people are familiar with the procedure. We'll have a break in the morning, a break in the afternoon, and then we'll recess for 45 to 60 minutes for lunch. We try to start our hearings by 9 and as close to 5 o'clock as we can. Then we'll recess for the next day. The other thing that hearing examiner Schaefer and I have discussed that we plan to do, since we have approximately 33 witnesses in this case that we need to get through with the 9 interveners, staff, and the company. At the end of the day, we'll just sort of take stock of where we've been and where we plan to go in the coming days. And we'd also like you to know, since this is your hearing, being you, the participants, you're going to need to keep us apprised of any changes or dates that your witnesses are not going to be available. We have attempted in reviewing the schedule that was proposed and in slightly modifying it, we've attempted to make sure that we will try to accommodate the parties' vacancies. Although, you know, we do have a bit of concern with regard to the number of SPS witnesses that don't seem to be available, which is a bit disappointing considering this is the SPS case, during the second week. You know, I count 4 that aren't available at all during the second week. And then there are 4 that aren't available the 26th, 27th, or 28th, or some combination of that. So SPS, make sure that we get all those witnesses that you're saying are not available next week. Better be heard this week. Okay, with that, hearing examiner Schaefer, I know we were having some Dropbox issues this morning. Sir, is there anything else that you would like to address at this particular time?
Hearing examiner Hurst, and I'm not sure if the parties are able to access the Dropbox, but I think our firewall here is creating some issues. So if you can just bear with us, that would be much appreciated.
Okay.
Madam Hearing Examiner?
Ms. Drake.
Good morning. I just wanted to deal with an initial procedural issue. As we noted in our pre-hearing memorandum, we, Ms. Miller and I, may come and go throughout the hearing. So we would like to request to be excused to come and go, with the understanding that if both of us are absent, we waive our right to object all matters addressed during the time that we are both absent.
Very well. Thank you, Ms. Drake. Yes, I appreciate that. That is generally the procedure that we utilize, is that if the party needs to be somewhere else and are unavailable for any of the cross-examination or cross-examination or procedural matters, if you're not here, you can't participate. So yes, you will have waived those, and that so thank you for that. And also I neglected to mention that as requested, we will start at 9 tomorrow, and then shortly before 10, we will recess from 10 to noon, and then plus lunch, so that the parties can attend the commission's open meeting regarding the new docketing system. Okay. If we don't have any further procedural matters, I'll just note for the record that we are working on the 2 outstanding motions. Motion in limine and the motion to strike, and decisions will be issued soon. Ms. Lynch?
Yes, thank you. I know that we're dealing with a number of scheduling issues. I just wanted to reaffirm that the witnesses for CCAE and Prosperity Works will not be available on January 23rd. And I am going to need to be excused from the hearing on the 23rd because I will not be available.
Okay. Thank you.
Yep.
And depending on how accurate people were on their cross-examination time, I do not anticipate getting to the staff and intervener witnesses and until at least Tuesday, if not Wednesday, of next week, unless parties pleasantly surprise me. That's kind of how when I was charting it out this weekend, that it looked like to me. So, all right. Well, if we have nothing further procedurally, we will begin the evidentiary portion of our hearing. Ms. Hardy, you have a witness.
We do, Madam Examiner. SPS calls its first witness, Mr. Adrian J. Rodriguez.
Good morning, Mr. Rodriguez.
Morning, Madam Hearing Examiner Hurst. It's good to see you again.
Good to see you. Mr. Lee, would you please swear in the witness?
Mr. Rodriguez, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth.
Yes.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Hardy.
Thank you. Mr. Rodriguez, can you please state your full name for the record?
Yes. Adrian Jose Rodriguez.
By whom are you employed and in what capacity?
Southwestern Public Service Company as president.
Do you have in front of you a document that is marked as SPS Exhibit 1?
Yes.
Can you please identify that document?
The document is titled Direct Testimony of Adrian J. Rodriguez on behalf of Southwestern Public Service Company.
And was that document, which is your direct testimony, prepared by you or under your direct supervision and control?
Yes.
If you were asked the questions in your direct testimony today, would they still be the same, your answers?
Yes. Yes.
Thank you. With that, Madam Examiner, I move the admission of SPS Exhibit 1.
Mr. Rodriguez, did you have attachments to your testimony?
Yes. One attachment relating to my background.
Okay, very well. Any objection to what's been identified as SPS Exhibit 1, the direct testimony of Mr. Rodriguez as affirmed by him here today? Hearing no objection, SPS Exhibit 1 is admitted. Ms. Hardy?
Thank you, Madam Examiner. I have no further questions for Mr. Rodriguez. He's available for questions from the parties, Your Honors.
Thank you. And I believe based upon the agreed upon the agreed upon order of cross-examination, our first cross-examiner will be, who reserved time for Mr. Rodriguez, will be large customer group. Is that correct?
That's
20
my
minutes?
understanding, Your Honor. Thank you.
Go ahead, sir.
Excuse me, Madam Hearing Examiner, on the order of examination of witnesses that you sent out, the spreadsheet, you have utility staff going first?
Well, that was supposed to be for presentation of, it's presentation of witnesses. It's mistitled, Miss Amer. Okay,
Okay, thank you.
uh-huh. Go ahead, sir. Identify yourself.
Yep. Good morning, Mr. Rodriguez. For the record, I'm Nick Stoffel, one of the attorneys representing the New Mexico Large Customer Group in this proceeding.
Good morning, Mr. Stoffel.
I have a few different topics to discuss with you this morning, which provide context for the upcoming discussion with the other SPS witnesses and intervener witnesses. And I'd like to start with a high-level discussion about SPS and its system of generation and transmission resources. So SPS is a multi-jurisdictional, vertically integrated utility, correct?
Yes.
And by multi-jurisdictional, SPS currently has 3 jurisdictions of customers it serves. Is that right?
Yes. Texas, New Mexico, and federal.
And federal or wholesale customers, is that?
Yes.
And the wholesale loads that SPS serves are exiting the system, exiting SPS's supply later in 2026. Is that right?
For those that take wholesale production service, yes.
So by the time the resources proposed in this proceeding come online, SPS will really have 2 jurisdictions, New Mexico and Texas, right?
We will still, however, have wholesale transmission service. And we are regulated by the Federal Energy Regulatory Commission for transmission lines that are in Oklahoma and Kansas, even though we do not provide retail or wholesale service in those jurisdictions.
And for the generation resources that are proposed in this proceeding, those were not proposed to serve wholesale loads other than the transmission service the company provides, right?
That is correct.
And SPS operates as a single integrated system serving customers in New Mexico and Texas, correct?
Yes.
And SPS is also a member of the Southwest Power Pool, or SPP, right?
Yes.
And SPS is a load responsible entity within SPP, correct?
Yes.
So as a load responsible entity, SPS must comply with SPP's planning policies and have sufficient generating capacity to serve SPS's peak load, correct?
Yes, as a member of the Southwest Power Pool Regional Transmission Organization, and our duties as a load serving entity. Yes.
So SPP can impose certain requirements on SPS, right?
Yes.
And one of those requirements is a resource adequacy requirement. Is that right?
Yes.
And I won't take you into the nitty-gritty of the SPP tariff on resource adequacy, but generally that requires SPS to have a certain amount of accredited capacity as determined by SPP, right?
Yes.
SPP determines both the amount of accredited capacity required and the methodology for capacity accreditation, correct?
Yes.
And one of the drivers of SPS's resource need is the higher capacity requirements established by SPP. Is that fair?
Among the other issues identified, yes.
So much like SPS operates as a single integrated system to serve customers in New Mexico and Texas, SPS complies with SPP's resource adequacy requirements on a system-wide basis, right?
Yes.
And so to make sure that's clear, SPS does not participate in SPP separately as SPP Texas and as SPS Texas and SPS New Mexico, right?
That is correct. We operate as one single system in the Southwest Power Pool.
And so while SPS operates as one single system within the Southwest Power Pool, SPS must also comply with the state law in New Mexico and Texas, right?
Yes.
you agree that the state energy policies in New Mexico and Texas are different, right?
Yes.
Would you agree that the state energy policies in New Mexico and Texas are divergent?
On some issues, yes, and on other issues, no.
So, for example, New Mexico has the Renewable Portfolio Standard, or RPS, which generally requires utilities to use zero carbon resources to serve customers in New Mexico beginning in 2045, correct?
While that does not state the statute in its entirety, that is an example of a law in New Mexico that is not in Texas.
You got to my next question. Texas does not have a renewable portfolio standard, correct?
Not one that operates similar to New Mexico.
And you do not expect Texas will adopt an RPS similar to New Mexico's in the near future, do you?
I cannot speculate on what Texas may or may not do in its legislative session.
SPS currently has an application for approval of the proposed self-build projects pending before the Public Utility Commission of Texas, right?
Yes.
And intervener testimony was filed in that proceeding last week, is that correct?
Yes.
And there are some parties in the Texas proceeding who oppose some or all of the proposed resources, right?
Yes, consistent with most regulatory filings.
And do any of the parties oppose the proposed renewable resources or battery storage resources?
While I have not read every piece of testimony at this point in time, I understand that there are some parties who have opposition for various reasons to different resources in the Texas proceeding.
And as we sit here today, much like we don't know what the Texas legislature might do, we do not know if the PUC of Texas will approve all of the proposed self-build resources, right?
We certainly hope that they will.
But we don't know if they will, correct?
That is a decision for the Texas Commission, as this case is a decision for the New Mexico Commission.
And the last time SPS brought or sought CCNs from the commissions in Texas and New Mexico, the PUC of Texas did not approve all of the proposed resources, correct?
As has occurred in prior cases, yes.
And so specifically, the PUC of Texas did not approve the Cunningham Battery Energy Storage System, or BESS. Is that right?
Madam Examiner, I have an objection.
Okay.
And it's that these questions are outside the scope of Mr. Rodriguez's testimony in this proceeding. I don't think he's here testifying about what's happening in Texas. and what
Permission to
happened in
respond?
Texas.
Well, let her finish.
Oh, my apologies.
And regarding what has happened in the past in prior proceedings in Texas.
Now may I respond?
Yes.
These questions are relevant to the issues in this case, including Mr. Rodriguez's testimony, which touches on the jurisdictional allocation of the proposed resources. And one of the issues that we've run into before that I'm laying the foundation for is different decisions from the commissions in Texas and New Mexico regarding which resources are approved and therefore available to be allocated between the two jurisdictions. So this is squarely at issue in the case and at issue in Mr. Rodriguez's testimony.
Ms. Hardy.
I think that Mr. Stoffel is free to raise that issue in briefing, but I don't think that Mr. Rodriguez's direct testimony encompasses what's happening in Texas and what has happened in Texas in the past.
Well, Mr. Rodriguez, you're the president of SPS, right?
Yes, Madam Hearing Examiner.
And so can I assume the buck stops with you?
Yes.
Overruled. You can answer the question if you know, sir.
Mr. Stoffel, would you please repeat the question?
Yes. In SPS's last CCN proceeding in Texas, the PUC of Texas did not approve the Cunningham Battery Energy Storage System, or BESS, correct?
That is my recollection, yes.
And in SPS's pending rate case in New Mexico, SPS has proposed to directly assign the Cunningham BESS to New Mexico, correct?
Yes, that is a request pending in our New Mexico rate case proceeding.
And with direct assignment, New Mexico would get all of the costs and all of the benefits for the direct assigned resource. Is that right?
Yes, as we have proposed it.
And a key benefit of a battery storage resource is the capacity it provides to the system, right?
Yes, among other benefits that may be identified by the accrediting entity.
Are you aware of any other resources that were approved by the PUC of Texas but denied by the New Mexico PRC?
I do not have all of our proceedings in front of us, so there may be some, but I am not aware of it. Cannot recall any at this time.
So SPS planned and selected resources on a system-wide basis, referred to as the multi-jurisdictional baseline, or MJB, prior to evaluating how to comply with New Mexico's renewable portfolio standard requirements, correct?
Yes, in order to plan for the system.
And SPS makes its resource decisions based on reliability and the economic value of alternatives, among other factors, right?
Yes.
As you testify, the proposed self-build resource additions are expected to provide significant benefits to customers from avoided fuel costs and tax credits, correct?
Yes.
And the actual avoided fuel costs and tax credit benefits from renewable resources ultimately depends on how those resources actually perform, correct?
As with any renewable resource, that is correct.
So after establishing the multi-jurisdictional baseline, SPS evaluated how that portfolio complied with New Mexico's RPS requirement, right?
That is my understanding, yes. And for further information, please see the direct testimony of Mr. Justin Gable.
Absolutely. And generally, though, that analysis focused on New Mexico's renewable portfolio standard in 2030, correct?
Yes.
SPS did not attempt to comply with the zero carbon resource requirement in 2045 as part of the resource evaluation and selection process, correct?
I will need to defer to Mr. Gable in terms of the details related to the analysis.
SPS did not evaluate alternative approaches to allocating resources between New Mexico and Texas that could support RPS compliance, did it?
Again, we do the multi-jurisdictional baseline in order to plan for a system, which is what we operate today, recognizing that if there are changes in statutes, that we may need to assess how we operate the system and allocate resources going forward.
And so with the multi-jurisdictional baseline, SPS determined it would require additional renewable energy to comply with New Mexico's renewable portfolio standard in 2030, right?
Yes, and that was the additional resources that were selected and per our request to be allocated to the state of New Mexico for compliance with the renewable portfolio standard requirement.
And you mentioned resources, but as we sit here today, there's one project, the Sandy Loam project, that is intended to support compliance with New Mexico's RPS in 2030, right?
Yes, given negotiations with the parties, given other factors, and given the results of the bids that we received in response to our request for proposals.
And SPS proposes that 100% of the cost for that RPS resource be directly assigned to New Mexico. Is that right?
Yes.
And you agree that if 100% of the costs of a resource are directly assigned to New Mexico, then New Mexico should get 100% of the benefits, right?
Again, I do not know if there are any statutory or regulatory requirements that we need to be mindful of. So I am concerned about declaring a perspective on that. I would do that consistent with the law and the rules of the Southwest Power Pool.
But so long as the laws and the rules of the Southwest Power Pool do not prohibit New Mexico receiving 100% of the benefits, you believe that's the correct outcome?
In terms of allocation or accreditation of the resources, and that is a question I'm uncertain about how we are defining benefits.
Well, all of the benefits should flow to New Mexico if New Mexico is assigned 100% of the cost. That's the key. I'm not asking you to opine on any specific benefit.
I recognize that sometimes there may be a locational issue, for example, property tax payments that may be made that are impacting the location where a particular resource is located. And that I would not want my response to impact payments and tax payments made because of the physical location of a facility. But as a general matter, I would agree that accreditation of the capacity or at least the benefits as required would then flow to the state.
I appreciate that clarification. And even with all of the generation proposed in this proceeding, and the long-term power purchase agreements that were also identified through the 2024 request for proposals, SPS will still need to procure more generation by 2030 to meet capacity requirements for winter of 2030, correct?
Yes, as well as growing load in our service territory.
And SPS will solve for its future resource needs based on the capacity of all of its existing or expected resources, correct?
As it stands today, that is what we're proposing to do.
And that would include, for example, the capacity and energy from resources that are proposed to be directly assigned to New Mexico, right?
Yes.
And the capacity from any direct assigned resources will also be used by SPS to comply with SPP's resource adequacy requirements as a system, right?
I'm going to object to the question, Madam Examiner.
Okay, Ms. Hardy, what's your objection?
That this is outside the scope of Mr. Rodriguez's testimony. We have other witnesses addressing the capacity issue. Assignment.
Permission to respond?
You're finished, Ms. Hardy?
Yes, thank you.
Okay, go ahead, Mr. Stoffel.
This continues to be relevant to the issue of jurisdictional allocation. And while there are other witnesses who address it specifically, and we will get into those details with them, I am addressing it at a high level with Mr. Rodriguez, both based on his familiarity with SPS's system, compliance with SPP's resource adequacy requirements, and system planning that, as he just acknowledged, will be based on direct assigned resources in addition to other system resources.
Overruled. Answer if you know, sir.
Mr. Stoffel, could you please repeat the pending question?
Yeah, the capacity from any direct assigned resources will also be used by SPS to comply with SPP's resource adequacy requirements as a system, correct?
Yes, because those resources are available to serve load within our service territory.
You're at 1 minute, Mr. Stoffel.
Thank you. I might need to borrow from some future time that I'm happy to surrender here. In this proceeding, SPS is requesting approval of its proposed jurisdictional allocation of the self-billed resources.
Sorry, Mr. Stoffel, can you start your question again? In
Yes.
this proceeding?
In this proceeding, SPS is requesting approval of its proposed jurisdictional allocation of the self-billed resources between New Mexico and Texas, correct?
Yes.
And as we established earlier, we do not know, sitting here today, if New Mexico and Texas will agree on the resources that should be allocated between New Mexico and Texas, correct?
As we do with every proceeding as a multi-jurisdictional utility.
And you agree that the direct assignment of a resource can change a jurisdiction's need for other energy or capacity resources, correct?
Generally, yes, but there are other witnesses who can provide a specific answer related to those impacts because of their subject matter expertise.
Among the resources that SPS seeks a decision regarding jurisdictional allocation in this proceeding are the Gaines and Tolk gas plants, correct?
Yes.
And SPS assumed a 40-year depreciable life for the proposed Gaines and Tolk projects in evaluating the different resource portfolios, correct?
Generally, yes, but Mr. Gable, who conducted the analysis, will have further detail on the analysis and how it was structured.
But you understand that the assumed lives would extend beyond 2045, correct?
Yes.
And in this proceeding, SPS is requesting an exception to New Mexico's 2045 zero carbon requirement to the extent the commission deems it necessary in order to approve those plants. Is that right?
Consistent with the explicit language of the Renewable Energy Act. Yes.
Would you agree that the requested exemption is intended to protect customers?
Yes.
Is the same true for the designation of the portion of Gaines as a zero carbon resource?
Yes.
And you would also agree that the requested exemption and zero carbon resource designation are only necessary to the extent those plants are allocated to New Mexico, right?
I'm sorry, would you please repeat the question?
You would also agree that the requested exemption from the RPS and zero carbon resource designation are only necessary to the extent those gas plants are allocated to New Mexico, correct?
For the portion of those plants that are allocated to New Mexico, yes.
SPS would be willing to move forward with the proposed self-build projects without a decision regarding jurisdictional allocation in this proceeding, correct?
Yes, as outlined in the proposals submitted by SPS witness Zoe Lease.
And similarly, SPS would be willing to move forward with the proposed self-build projects without a decision regarding the requested RPS exemption or the zero carbon designation. Is that right?
We will always evaluate given the risks at a particular point in time. But again, those proposals are outlined in the testimony of Zoe Lease.
Thank you, Mr. Rodriguez. Thank you, Madam Hurst. I have no further questions and appreciate the additional time.
Thank you, Mr. Stoffel.
Thank you, sir. You are over by 2.
Take it from Mr. Gable, please.
All right, -2. Thank you. I believe the next party that reserved time for Mr. Rodriguez was CCAE, 10 minutes. Mr. DeSalen or Ms. Lynch?
Thank you, hearing examiner. I have just a couple of questions.
Go ahead.
Hello, Mr. Rodriguez.
Good morning, Ms. Lynch.
Let's see here. I'm having some technology issues with how the system works, so I'll be navigating that and appreciate your patience. All right, so I just have a few questions. To begin with, one is a general question. Does SPS require firm contractual commitments for projected projects that may add to load?
SPS requires for large loads to go through the AQ study process of the Southwest Power Pool. So, and which ultimately result in energy services, or excuse me, electric service agreements.
And is that, in your mind, a firm contractual commitment?
In some instances, yes, and in some instances, no.
Is there a difference between when those require a yes for a firm contractual commitment and those that do not?
There are instances in which a customer does not end up putting load on the system. And there are instances in which we have to serve load that was unanticipated on the system because of a growing industry.
Is there any way for SPS to be assured that a projected project will actually take place?
SPS is evaluating for certain large loads a proceeding or submitting a request for a large load tariff, which would provide further detail for extremely large loads.
Okay, thank you. If you would please turn to page 33 of your direct testimony.
Okay.
Let me know when you're there.
Okay. I am now on page 33 of my direct testimony.
Okay. At lines 1 through 9, you discuss interconnections. And there you state that for interconnections, SPS prefers the surplus interconnection process, correct?
This pertains to interconnections related to generating resources, and the testimony begins on page 32 in response to the question on lines 8 and 9. So yes, as it pertains to the interconnection of new generating resources.
Does this mean that for some generation projects, SPS installs interconnections that can handle more generation than what is required?
I apologize, Ms. Lynch. I do not fully understand that question. There is interconnection of a customer onto the system, which goes through the Southwest Power Pool's AQ study process. The question that we are looking at here pertains to the interconnection of a generating resource in the Southwest Power Pool.
Does SPS ever install interconnections greater than what SPS may be required for its generation systems?
Ms. Lynch, I apologize, but I do not understand that question.
Okay, we'll move on.
Okay.
On page 34, 9 through 11, you state the Gaines County gas plant in particular will place dispatchable generation closer to the load growth from SPS customers and hobs. Is that correct?
I am on page 34, and what you were discussing is in response to questions on page 34, lines 6 and 7. Yes, that text is in my response.
Where exactly is that dispatchable energy used?
The dispatchable energy is used across the entire system for the benefit of the entire system. The reason why I discuss that it is closer to the load growth is for the benefit that it provides to the transmission system by having grid stabilization capabilities, given that the load is close to the generating resource.
Okay. Can you please turn to page 35?
I'm on page 35.
Okay. There at lines 5 through 6, you began a sentence. The final preferred portfolio includes 15 resources to meet SPS's capacity needs and 2 resources for RPS 2030 compliance purposes. And then you continue. Does SPS not use RPS compliant resources to meet capacity needs?
First, I want to clarify the testimony utilizing my conformed copy that was admitted as Exhibit 1 in this proceeding, and it restates the resource that was available that is now the available RPS 2030 resource on line 6, which includes the revision. And so there are, in terms of responding to your question, I want to make sure that I understand the question correctly. Can you please restate the question?
Yes, my question is, does SPS use RPS compliant resources to meet capacity-wide needs?
Yes, as would be required, or as we do with any renewable resource, no matter where it is located.
Okay, thank you. Could you please now turn to page 38?
I'm now on page 38 of my direct testimony.
Okay. You provide a table of the projects proposed at line 1. Do you see that table?
Yes.
Some projects have accredited capacity amounts significantly lower than the nameplate capacity. Is that correct?
Yes.
Why, for example, do the Sandy Loam and Yellow House projects have such low accredited capacity amounts compared to their nameplate capacity amounts?
First, I would note that there is a subject matter expert who can provide further detail on accreditation in the Southwest Power Pool, Mr. Jared Cooley. However, these accredited capacities are evaluated based on their performance, on expected performance of the resource in the Southwest Power Pool, consistent to how it is accredited in the Southwest Power Pool.
Why does SPS build facilities with much higher nameplate capacity than accredited capacity?
That is not an issue specific to Southwestern Public Service Company. The industry will always will utilize a resource with a nameplate capacity that differs from its accredited capacity, given the resource's performance or how it is accredited consistent with studies that are performed by the accrediting entity.
Got 1 minute, Ms. Lynch.
Thank you. Does accredited capacity affect the cost to build the facility?
Unfortunately, Ms. Lynch, I do not know the impact. I know how we evaluate the bids that were responsive to our request for proposals.
So ratepayers must pay for the entire facility with a nameplate capacity, even though the accredited capacity may be less than what the facility can provide. Correct?
As with any resource of any type, anywhere in the country.
Thank you. And that concludes my questioning, Ms. Hurst.
Thank you, Ms. Lynch. You have
Thank you, Ms. Lynch.
reserved 10 minutes in your capacity as counsel for Prosperity Works.
I yield that time. Thank you.
Thank you. Mr. Harris, I believe that New Mexico Department of Justice reserved 15 minutes for Mr. Rodriguez.
I'm going to yield that time. I have no additional questions for Mr. Rodriguez.
Very well, thank you. Our final questioner, I believe, Ms. Lang, Ms. Amer, I believe staff has reserved 45 minutes for Mr. Rodriguez.
Yes, Madam Hearing Examiner, and I do not think we will need the entire 45 minutes because some of our questions have already been asked and answered.
Very well, go ahead.
Good morning, Mr. Rodriguez. nice to see you again. I'm Judith.
Morning, Ms. Amer.
I'm an attorney for the New Mexico Public Regulation Commission Utility. Your testimony touches on very similar topics as Miss Lee's. Is there a reason that you both filed testimony?
Yes, my testimony provides a high-level description of the company and other general matters related to how we operate, and Ms. Lee's handles a more detailed evaluation of the resources and the requests in this proceeding.
That being said, is it okay if I ask you some of the questions that I may also ask her?
I have no objection to the questions that you ask, Ms. Amer.
I just want to let you know that there may be some.
My attorney may, however.
There may be some similarities. So is it correct that this is a case about need for resources due to a combination of factors, such as the increase in the SPP winter PRM, load requests for electric connection for oil and gas, and the fact that there may be deficiency payments if if SPS does not meet the winter PRM. Is that correct?
Objection, Madam Examiner.
Ms. Hardy?
I think that was a very long and confusing compound question.
It was a compound question. You want to break it up, Ms. Amer?
Yes. Is it correct that this is a case about need for resources?
Yes.
And is the need for resources due to a combination of factors?
Yes, as outlined in our request.
And is one of the factors that SPP increased its winter PRM to 36%?
Yes, among the other factors identified in testimony, including an increase in the summer planning reserve margin.
Correct. And has SPP notified SPS that if SPS does not meet that winter reserve margin, it would be subject to deficiency payments?
While I am not aware of a direct notification, that is the rules under which we operate as a member of the Southwest Power Pool Regional Transmission Organization.
Are you aware that in the application, SPS stated that, and in a variety of testimonies, SPS stated that it would be subject to deficiency payments?
That is correct.
And are you aware that in your application and testimonies that it was stated that this portfolio represents the most cost-effective way for ratepayers to not be subject to deficiency payments?
It is the lowest cost portfolio in response to our request for proposals in order to meet the required load and planning reserve margins for our customers.
And if you don't meet the winter reserve margin of SPP, customers will need to pay deficiency payments. Did your testimony state that and the application?
Southwestern Public Service Company and its customers could be impacted by deficiency payments if we do not meet planning reserve margins.
And why should SPS's ratepayers pay any deficiency payments?
One of the reasons that we are moving forward with this is so that we do not have customers paying for deficiency payments by meeting the planning reserve margin requirements and being able to continue to provide safe and reliable service to our customers.
But if deficiency payments are required to be paid, why should customers pay them? Why shouldn't answer that question?
I'm sorry, could you please restate the question?
If deficiency payments are required to be paid, why would those payments be assessed to SPS's customers?
Our customers pay for the impacts to the system as a regulated utility, and these would be the costs that we have of doing business in the regional transmission organization. So until that is the cost of operating a regulated utility for which our customers are part of. And in this case, we can address and minimize the impact of any deficiency payment, which is precisely why we have made this request for new generating resources.
Isn't a deficiency payment similar to a penalty?
I object to the question.
Okay, on what basis?
I think it's calling for a legal conclusion as to the difference between a penalty and a deficiency payment.
May I respond?
Yes, ma'am.
I'm not asking for a legal conclusion. I am just asking if a deficiency payment is different than in the ordinary course of business or different than dues. It is something, I'm asking whether a deficiency payment is in the form of, for lack of a better word, you did something wrong. You're late, something.
Okay, that's like three questions there, Miss Amer, and it's actually a different question than what you asked. So you asked, is a deficiency payment similar to a penalty? That was objected to. I think it's calling for a legal conclusion, and you say you're not asking for a legal conclusion. So I'm going to rule on that. And I'm going to overrule the objection. And you can answer if you know, Mr. Rodriguez.
It is a stated tariff, and one of the rules under which we operate, whether or not is a penalty or not, is unknown. And I note that the planning reserve margin was changed during the course of our integrated resource planning process, and multiple utilities in the Southwest Power Pool are operating under these rules and are trying to augment their generation with requests such as the one that we have pending here in order to address those changes in the planning reserve margin.
Okay, so your testimony is that a deficiency payment is a term in the tariff, correct?
As I understand it, Madam Hearing Examiner, I do not have that text in front of me.
Okay, well, I'm reading your answer. It's a stated tariff and one of the rules under which we operate. Whether or not it is a penalty is unknown. Okay, so if this is a term that's in the tariff, does the tariff define this term?
It is determined based off of a calculation on available loads and the established planning reserve margins in the power pool.
Okay, so you're telling me how it's calculated, but I want to know if the term is defined either in any of the rules or in the tariff.
Madam Hearing, I would need to follow up on that issue. I do not have the specific text in front of me. I know generally what it is, but I do not know the specifics, and I would not want to give a misstate whether it is a defined term in that tariff or not.
Very well. Ms. Hardy, consider that a bench request, one. I'd like to know whether or not the term deficiency payment is actually defined in the tariff or rules as referenced by Mr. Rodriguez, rules under which we operate. Okay, is that clear?
Yes, thank you.
Okay, very well. Okay, I had stopped your time, Miss Amer, so I'll start it back. Go ahead.
Thank you. Is the deficiency payment triggered on a particular date and time?
I do not know, Ms. Amer. But we have witnesses who can testify on the specific calculations and when that calculation occurs.
Who would that be, Mr. Rodriguez?
It would be Mr. Jared Cooley.
Very well, thank you. Go ahead, Miss Amer.
Isn't it true that SPS has complete control over events leading to deficiency?
Ms. Amer, no, we operate under the statutes and laws in our two jurisdictions and must comply with those and try to align them with the timing of the various entities in which we operate.
Do SPS's customers have any control at this point in time or at any point in time over whether or not SPS is required to pay deficiency payments?
Our customers exercise that control through this commission and the commission under which we operate in Texas and at the federal level.
But specific customers, a retail customer in SPS's jurisdiction right now has no control over whether or not SPS will be assessed a deficiency payment.
That is correct. They can advocate, however, for us to have these resources approved in this proceeding.
Then can you explain why you think it's fair, just reasonable for that retail customer to pay any deficiency payment?
Ms. Amer, the planning reserve margin was changed at the Southwest Power Pool during the course of this integrated resource planning proceeding. While I do not like the fact that any payment would have to be made, it is a payment and a cost that we would be assessed if we are not able to meet the planning reserve margin requirements, which this proceeding is attempting to address.
Do you think it's reasonable for SPS to pay all of the deficiency payments, if any, are assessed? The shareholders?
Ms. Amer, whether it is reasonable, it is a fact of our membership as part of the regional transmission organization.
That's not what I'm asking. I'm asking, do you think it's reasonable for the shareholders and not the customers to pay the entire amount of deficiency payments?
We have a proceeding and a request before the Public Regulation Commission for the commission to guide us on that request.
But you do agree that the retail customer in SPS's territory right now has no control over that? Over the deficient.
Well, I object. I think it misstates testimony, Madam Examiner.
You think it misstates what?
His testimony
In what way?
that I believe he's testified that customers exercise control through this commission and through their participation in this proceeding.
Okay, the testimony will stand for what the witness, for how the witness answered it. Go ahead, Ms. Amer.
Okay, I'm going to change to another topic now. I'm going to ask you that this is a very important case. Do you agree?
Yes.
And a large portion of the resources, in particular Gaines and Tolk, are dependent on a request by SPS for either an exception to the REA or a designation as zero carbon resources. Is that correct?
Yes, as requested in our application.
And do you agree that this commission has not dealt with that request in any other case prior to this?
I am not aware of other cases in which this request has been made.
So do you agree that this is a case of first impression?
Yes, assuming that this request was not teed up in another case.
And do you agree that we could call this a brand new legal theory?
No, we are following the explicit text of the Renewable Energy Act.
Well, then I have to ask you, where in the Renewable Energy Act does it use the word exception?
I'm sorry, I do not have the act in front of me, but it is I am aware of what the statute states that the commission shall do.
Correct. I mean, I can read you the language. And perhaps we could take a break so you could review the language. I would like to know whether or not the Renewable Energy Act uses the word exception.
I'm not aware of where that word is in the statute.
Okay, so you don't want to call this a brand new legal theory, but you do agree it's a case of first impression. Is that correct?
I agree that the commission has not ruled on an issue that has been raised, but this issue is raised consistent with the explicit text of the statute.
The commission has not ruled on this issue before. Does SPS consider it risky to base its very important case on a case of first impression?
Ms. Amer, we will strive to provide safe and reliable electric service, and we will follow the laws of the state of New Mexico. And our request is consistent with the provisions that the statute states that the commission shall consider.
Would it have been safer for SPS to rely on a case has decided prior rather than a...
Sorry, Judge, she's breaking up. Judge?
Yes.
video?
I cannot, I did not hear the rest of the question.
Okay. Ms. Amer, restate the question.
would it have been safer for SPS to base this very important case on commission established precedent?
I object, Madam Examiner.
Ms. Hardy?
I don't know what Ms. Amer means by safer. I think it's a confusing question.
Less risky?
I have
Ms.
the same
Hardy?
objection. Less risky how?
You want to put your question in context? Ms. Amer?
Yes. You realize that there is commission precedent on many CCN issues. Is that correct?
Yes,
And,
consistent with the statutes in effect at the time of those CCN proceedings.
and you realize there's many cases established in commission precedent regarding the REA in general. Isn't that correct?
Yes, and that law has been amended over time.
And isn't it correct, as we stated, that this is the requests in this application are questions of first impression?
Yes,
Therefore, if a company had to submit an application based on commission precedent, that would be less risky than submitting a case of first impression.
no, Ms. Amer. My concern would then be that precedent may not have contemplated the statute in effect at the time that the case was finalized. So precedent alone is not guiding our decision. Our decision to file this case and to make the request we have made is consistent with the statute, in line with the precedent as it exists today.
But isn't it true that you do not know how the commission will rule on these issues of first impression?
That is correct.
And isn't it true that the commission may either decline to rule on them or deny the requests, either one?
Or the commission may reprove the request. Again, there are various options for the commission to decide.
And if the commission either declines to rule on the case of first impression or decides to reject them, will SPS build Gaines and Tolk gas plants?
Ms. Leese has outlined the options for the commission. There are circumstances under which, if we receive a denial in this case, we will not be able to build the gas plants for New Mexico customers.
If Texas denies the Gaines and Tolk plant, will SPS be able to build them?
Apologize, Ms. Amer, I missed the first part of the question related to Texas.
If Texas Commission denies the CCNs, although they call them something different there, in Texas for Gaines and Tolk, will SPS still build them?
We would need to assess that outcome. Again, we make a request in Texas and in this state with the hope and based on the evidence that our request is approved.
But you agree that there's a chance that New Mexico could approve Gaines and Tolk and Texas would not?
As with any proceeding, we must wait for a final decision of either commission.
And you also agree that Texas could approve Gaines and Tolk and New Mexico not.
Those various scenarios are possibilities.
So is it uncertain whether or not Gaines and Tolk are built until you receive approval from both New Mexico and Texas?
As we do with any generation or transmission request before our two states as a single system.
All right.
Miss Amber, why don't we take a break? It's 10:30.
Yeah.
You've got 22 minutes left
Okay.
of your time. And we'll recess for 10 minutes. We'll come back at 10:40. Remember, please, that the YouTube remains on during the break. Thank you. Okay. Mr. Lee, are we ready to go, sir?
Yes, Your Honor.
Very well. We're back from our recess. I believe you had some further questions, Miss Amer.
Yes, I do. Thank you.
Go ahead.
Thank you, Mr. Rodriguez, for your patience. You mentioned that, let me see. You mentioned that, Ms. Lee's laid out options in the event that the PRC does not grant exceptions or exemptions to the REA. What's your understanding of that?
I understand that Ms. Lees provided options for the commission in how it could move forward with this case.
Exactly, but what did she say? So that I don't
I
want
know,
to ask Mr. Rodriguez. So what's your understanding of what she recommended?
well, again, as a representative of the corporation, Ms. Lees has options for the commission as to how it can rule in this proceeding. Ultimately, our request is for approval of these resources consistent with the Renewable Energy Act.
Do you need an exception or a zero carbon designation in right now in 2026?
While that would be ideal, we would have to evaluate those options if we did not receive those. And again, Ms. Lee's testimony, rebuttal testimony outlines those specifically.
And why do you need the exceptions or the RE or the zero carbon designation now when the zero carbon requirement does not occur until 2045?
Part of that issue relates to certainty specific to the resources so that we can understand how we can move forward as it pertains to the recovery of those costs.
So if you don't receive those determinations now, you will not know, you will not be certain on recovery of those costs after 2045. Is that what you're saying?
If we do not receive those the requests that we have now, we will have a high degree of uncertainty and we will evaluate, of course, at that point in time. However, I note that consistent with what has been outlined in Ms. Lee's rebuttal testimony, we have provided options for us to be able to evaluate going forward. The reason why I am sensitive about this response is that I have to take into consideration the financial situation and the market impacts as well as various factors in order to not place our regulated utility at risk.
If you received approval of the CCNs for gains and costs, you did not receive a determination on the zero carbon or the exception, would that affect your credit rating or any kind of financial metric?
It could impact the credit rating and assessment of the risk of the organization, as well as how it is accounted for consistent with generally accepted accounting practices. So, as well as any other applicable rules that accountants follow related to the costs and impacts of a generation of any resource.
Is you're probably aware that several parties claimed that the request is not ripe at this time for a determination because it's not 2045. What is your opinion on that?
My opinion is that what we must avoid is a explicit ruling at this point in time that states that cost recovery is not allowed beyond 2045.
But just no ruling at all is something that you are not trying to avoid? I mean, I don't quite understand your answer. You
I'm
say
sorry, is there what, I didn't understand the question.
for the determination that cost recovery would not be allowed after 2045. So is silence an answer that you're trying to avoid?
An explicit ruling that denies recovery of costs beyond 2045 would be a ruling that would not allow us to move forward with building gains or toll for New Mexico customers.
Okay, I understand.
A ruling that does not explicitly rule, we would have to take under advisement and evaluate. But it might be possible in that scenario for us to move forward to build the plants for New Mexico customers.
Thank you. I have some questions about economic development. In the time remaining, I don't know. You mentioned that these resources additions would benefit New Mexico for economic development. Are you talking about new economic development? New companies?
New and existing, as well as our New Mexico customers who would live in the communities that would benefit by having these growing or new employers near their community.
Is there, but some of the economic development isn't actually new. Is that correct? It's existing oil and gas companies that may want to expand or electrify.
Too many questions in the same question, Ms. Amer. Let him answer one.
Some of the economic development is existing, correct? Is what you're saying.
First, I would highlight that Mr. Teisling provides further subject matter expertise on this question. In any case, some of the customers are existing, but they are trying to maintain their operations and therefore the employment of New Mexicans as part of their operations.
The economic development you refer to in your testimony, how much of it is new?
Is there, I'm sorry, Ms. Amer, is there a specific location in my testimony that you would like to point me to?
Yes, but at this point, I don't know if I have time, so I don't know if I can do that right this minute. I do know that you use the phrase economic development.
And I'm not sure if there's a question or what it is right now.
When you use that term, what percentage is new?
Well, I can't provide a specific percent of what is new. One thing to highlight is that if let's, for example, say that an industry leaves New Mexico, but another comes in and takes the load that entity was utilizing and is able to employ more New Mexicans. Those are instances that can occur. So a specific percentage is not something that I am referring to in my testimony. What I highlight is that we are serving load. Some of it may shift and some of it may be for new entities. But again, Mr. Teisling has further detail in his analysis.
How many interconnection requests do you have waiting?
Plenty. And more than we can probably serve because many are still awaiting moving through the Southwest Power Pool Tariff AQ study process. For more detail in the number, Mr. Cooley and Mr. Gable we'll be able to provide further detail.
Do you know how many are in the AQ study process?
There are those that have completed the AQ study process, and then there are those that are awaiting to go through that process. I do not have a specific number in front of me.
So we should ask Mr. Cooley or Mr. Gable.
Yes.
There's certain existing oil and gas operators in southeastern New Mexico that have expressed an intent to electrify. Is that correct?
Yes.
Do you know how many?
We have provided a methane analysis study. And while I may not be able to provide a precise number at this moment, that study provides information that we were provided by our customers in order to show what the impact of our facilities would have on their electrification efforts.
It's a choice for those companies, isn't it correct?
While I do not operate or am I responsible directly for one of our customers' industries, there are greenhouse gas emissions requirements that they must follow. There are also requirements that their management has imposed on them. And for various reasons, they are seeking or are required to electrify. And while I myself am not an operator or responsible for those entities, I believe there may be interveners in this proceeding who directly are.
But isn't it true they could choose not to connect to SPS's system?
They could choose not to connect to SPS's system, but that would be to the detriment of New Mexico, precisely because it would not allow them, or their operations would likely need to rely on diesel emissions, thereby further impacting the environment in New Mexico. I also, again, defer to our customers who may have specific legal requirements that are either federal or in the state of New Mexico that impact their operations that require them to electrify and would thereby need them to interconnect onto our system.
But isn't it true that it's not certain the number that will choose to connect to SPS?
I do not have that specific number at this time. I do know that there are plenty of tariff AQ study requests pending with the Southwest Power Pool.
And do you agree that they could build their own generation behind the meter?
It is not entirely clear what they could afford or not afford to do, or I also highlight the impact to New Mexicans if that were something that were allowed to occur.
I believe that's all my questions.
Thank you, Ms. Amer.
I don't know if I have any time left over.
Yep, you've got 8 minutes.
Can I just hold that in reserve for staff in case there was someone that we only put 5 minutes for and we needed more time?
Sure.
Thank you.
Thank you, Ms. Amer.
Thank you, Mr. Rodriguez.
I believe that that concludes the cross-examination from the parties. I'm not sure whether or not the commissioners have questions for Mr. Rodriguez.
Hearing examiner Hertz, this is Commissioner O'Connell. I just had one follow-up from an earlier exchange.
Go ahead, sir.
Good morning, Mr. Rodriguez.
Good morning, Commissioner O'Connell.
Hey, I was listening when you were having your exchange with Mr. Stoffel, and he was talking about laws of New Mexico, laws of Texas, rules of SPP. Just wanted to know if there's any priority among those three. Are the rules of SPP more important somehow than the laws of Texas or New Mexico from SPS's point of view?
No, Commissioner O'Connell, the laws of Texas and New Mexico are what are paramount for us. We also operate under the Federal Energy Regulatory Commission's rules and any federal statutes. So I want to highlight that it is a balancing act, but that we follow the law and strive to comply with the law in Texas, New Mexico, and the federal government.
So in that balancing act, or is there any jurisdiction that is easier to bend its rules or laws than another?
I am not aware of any jurisdiction that bends its laws, Commissioner O'Connell. We follow the law as it is explicitly stated in all of our jurisdictions.
Thank you. No further questions.
Thank you, Commissioner.
Thank you, Commissioner O'Connell.
And hearing examiner, I have one follow-up question as well.
Very well, Mr. Chair.
Hi, Mr. Rodriguez. Good to see you.
Good morning, Chairman Aguilera.
So I just wanted to follow up on one of the last points that Ms. Amer was asking about, and she was asking about whether some of these larger customers that you serve, which I would argue are more sophisticated, and she was asking whether they can serve themselves. She asked behind the meter. You know, there's a new law with respect to microgrids in New Mexico, and you responded that you didn't know what their financial capabilities are, and you ended with, but it would be. I don't remember the exact phrasing, but I think you said something to the effect that it could have negative impacts to New Mexicans, or maybe it's to the detriment to New Mexicans. And I'm just wondering if you could elaborate on that. How would a large customer serving themselves, how would that negatively impact New Mexicans if they were to build their own generation?
The first is to highlight that if they could even afford to build their own generation, it does require a high degree of expertise. And while some of them may have the ability to do it, many do not. And as a result, rely on our electric system, including our transmission system, which then serves as a backup to any natural gas, renewable, or generation facility that they have on their side of the meter, meaning that an outage that they take on their side of the meter will then they will still be able to continue their operations. At that point, if they have a behind the meter generation and are not interconnected to the system, any outage on their system would likely result in a severe impact to their operations behind the meter. So that is the basis for my comment about the detriment, is that it then provides, it is the ability to continue operations is precisely why we have the relationship with our large commercial customers, even those that have the sophistication to build on their side of the meter. I also want to highlight that as we are going through an increased build in generation across the country, these operators would now be subject to the standard supply chain constraints and costs related to building their own generating resources.
Okay, thank you. And it seems like that's in response to the companies themselves as New Mexicans, maybe they're workers, and how about other New Mexicans who are residential retail customers? Would there be some kind of negative impact to them if these larger, more sophisticated customers built their own generation?
Part of the impact, and again, not knowing the specifics of or operations of one of these facilities, the providing safe, reliable electric service to these large customers at the lowest cost available benefits New Mexicans by allowing them to keep their operations running consistently, thereby allowing us to provide or be a part of the employer base for the state. So our residential customers in many cases are employed by the businesses and industries that support large commercial customers. And if they are able to continue operating, noting that not all of them are capable or want to provide their own generation on their side of the meter, this provides the consistent electric power that we can provide to customers to keep their businesses operating and to keep New Mexicans employed and these communities growing.
Okay, thank you. I understand the response. Good to see you, Mr. Rodriguez, and thank you for your time and for being here.
Thank you, Chairman Aguilera.
Yeah. Hearing examiner, that is all I had.
Thank you, Mr. Chair. I have a couple of questions, Mr. Rodriguez. Good morning.
Good morning.
And I have a couple
Madam
of
Hearing Examiner.
observations. Since the buck stops with you, I think you're probably aware that there's been some consternation and fear and some on the part of some of the participants in this case, and maybe even the commission, about the number of requests that SPS has put in this case. I don't know whether or not when you all were getting this filing ready, if you thought maybe you could have have broken it up into maybe asking less with your witnesses. But I think you would acknowledge, Mr. Rodriguez, that having 21 witnesses outside of a rate case is quite a number of witnesses, don't you think?
It is many witnesses, Madam Hearing Examiner, and that is something that we are very thoughtful of. I recognize, however, that the number, the speed, the demand, and the changes in the energy landscape are what has required us to make the requests that we are making, in all due respect to the hearing examiners and the commission.
I had occasion to look. I was looking for something that I couldn't find that I'm going to ask Ms. Lees about in her rate case testimony. But I noticed, did I count right? I think you got 29 witnesses in that case, right?
I don't have the specific number in front of me. I'm focused on this case at this moment.
Okay.
But I will follow up.
Well, again, I'm not trying to tell the company how to do its case. I'm just pointing out, like I say, I think as you're aware, the more you try to pack in to the case, and the more people you put, the burden is placed on trying to evaluate all that and to accommodate the time frames. And yes, it's our job and we'll do so. But I point that out, especially because I saw a lot of redundancy and overlap, I thought, in your witness's testimony. For example, in your own testimony, why did you put the same table twice?
Thank you, Madam Hearing Examiner. Did that for ease and reference in some cases for parties who just read the preliminary testimony at the very beginning. And that is the reason why wanted to make sure that in some cases, if we are referencing an item, if it becomes a standalone item in the hands of a hearing examiner or an intervener, that it is something that they can refer to rather than going then to testimony. So I apologize if that created an additional burden. It was an attempt for ease and reference throughout the case.
Well, I thought it was fine to put your table AJR-2, the self-build projects, on page 9, but I didn't really need to see it again on page 38. Because all my notes are on page 9. Also, for example, on the formatting of the testimony, well, you use on AJR-1 on page 14 a map of the current generation fleet and proposed projects. Okay, Ms. Lee's has that very same table in hers. So, there's also occasions where all the lines on testimony or all the pages, no, I'm saying it incorrectly, where a page might contain only 4 or 5 lines. And then to go to the next question, you have to go to the whole next page. So again, I just point out, for us, all of us who I'm sure read every page of this, I don't think we need to see things in a repetitive manner, and I'll just let it go at that.
We will take the feedback, Madam Hearing Examiner. Our team is listening, and we will get better.
I think I understand most of your testimony. I had a couple of clarification questions with regard to the self-build project, and obviously you can refer me to the specific witness as long as they get part of your pay. You know my rule.
Aware of the rule, Madam Hearing Examiner.
Absolutely. So if we look at page 9, the table AJR-2, the self-build project, my understanding was that SPS requested that the Oneida 2 solar at Harrington be withdrawn, correct?
Yes.
And that was going to be a direct assign project, wasn't it?
Yes, as we had requested it in our original filing.
Okay. So then basically our numbers are going to change here because we're going to take out that 631 million, right?
Yes.
Okay. So subject to check, it's approximately 9.384 with that taken out.
Madam Hearing Examiner, I understand that SPS Exhibit 1 contains the errata to specify the amount.
Okay. So are you familiar, and can I do it this way? If I want to look at that total number in that self-build project, at the bottom in the right-hand column, if I want to look at that number and I just want to get a ballpark idea of what the potential allocation is going to be to New Mexican ratepayers, can I look at page 1044 to Ms. Lee's testimony? It's attachment 1. It says it's I think an appendix M. It's basically a pie chart that has the the jurisdictional split. And what I would represent to you is under this jurisdictional sales split, it says Texas is 47%, wholesale is 23%, and New Mexico is 31%. Does that sound about right?
That would sound right as it pertains to the jurisdictional allocation of the split. Oneida 2 was a direct assigned resource that would not have been selected but for its but for the renewable portfolio standard requirement in New Mexico law. So withdrawing that facility from the request does not change the jurisdictional allocation of the system. It would lower the cost for New Mexico customers, but we still need to procure additional resources to comply with the renewable portfolio standard.
Right, but I'm just trying to get a ballpark number here. So, you know, and on that point, no, I realize that, but in the Sandy loan, that's a direct assignment too, right? That 472,682,000.
Yes.
Okay, no, I know all. So in under direct assignment, what you mean by that is all of that would go to the New Mexico jurisdiction, correct?
Yes.
Okay. No, I'm just wondering if you know, if I'm just trying to get a broad picture look here, if I'm to take out the direct assigned, the one that you withdrew, and then the Sandy loan, and I come up with a number, and I take 31% of that number for the jurisdictional split, and then I add back in the Sandy loan, is that going to give me a pretty good idea of what potentially New Mexico ratepayers might have to pay for?
Madam Hearing Examiner, can you direct me to the page in Ms. Lee's testimony, because we may need to follow up for a specific answer to you with a bench request. Normally, I would not suggest a bench request to the chagrin of my counsel. But in order to make sure that we are providing you with the specific answer that you are requesting, I would like us to highlight the page and then go through the calculation.
Sure. It says attachment ZEL-1, and then underneath that, this is in the right-hand corner of it, it says page 956 of 1,687. And then under that, it says Appendix M, page 17 of 738. And so yeah, I mean, we can consider it a bench request that I want to know the jurisdictional allocation from this self-build project chart after the errata. Okay.
Yes, and we can may require some context to walk through the calculation.
Okay.
Not having it in front of me. Thank you.
Does it sound wrong to you, or does it sound about right? I seem to recall in the testimony, and I can't put my finger on it right now, but it seems to me that one of the SPS witnesses indicated that if all the projects, if all of SPS's requests were granted and were in operation, and potentially the PPA projects too, which are in a different case. Is that right, sir?
That is correct.
I don't see where I had it written down, but I think it's 89, 79.
I will have to pull the docket number for that
Okay.
pursuit. Do not have in
Okay,
front of me.
but the PPA projects are in another docket, but they're affiliated with this docket,
Yes,
correct?
as well as a build transfer project that would be in a separate proceeding as well.
Right, but that hasn't been filed yet.
That is correct.
Okay. So anyway, back to somewhere I thought I read that if all of SBS's requests regarding these issues, there's a potential that New Mexico ratepayers would be paying approximately 40%.
Based on the jurisdictional allocation, and Madam Hearing Examiner, I also directed to the application, which I understand gives a large summary of the entire portfolio, so that it outlines the basis for the different proceedings, as well as the results of the multi-jurisdictional baseline.
So that's yes, 40%.
I believe so, Madam Hearing Examiner. Again, subject to the jurisdictional allocations as they exist today and that are evaluated by the commission in rate proceedings.
Okay. And just so that I'm clear, it wouldn't just be the self-built projects at your table on page 9, but we'd also have to look at your table on page 40, AJR-4, and that's entitled the Gaines County Transmission Network Upgrades, correct?
Yes.
Okay, so that is $461,571,853, right?
Yes.
So basically another $500 million added to this 9-point-something billion dollars, right?
That is correct. Those numbers, however, may decrease based on the interconnection costs that are evaluated by the Southwest Power Pool, as other projects may drop out, and thereby impacting the costs of transmission. I also highlight that this is a case of need to identify the resources that are necessary at the lowest cost portfolio that is available following a request for proposals process and subject to the New Mexico Integrated Resource Plan process.
And does this include the most up-to-date numbers? Because I thought I heard at the pre-hearing that there was something else that was going to be, I thought, another transmission line.
Madam Hearing Examiner, I do know that as it pertains to this proceeding, we have in rebuttal testimony noted the reason to no longer seek the request of a particular transmission line that is no longer viewed as necessary to interconnect the Gaines Power Station. However, the 3 transmission lines that are highlighted in my testimony there on page 38 are still deemed necessary. I'm sorry, let me rephrase. The Tolk to Potter transmission line is not part of the request subject to rebuttal testimony.
Okay, so then if I look at the table of AJR4, I could take out that $153,785,960.
That is my understanding, yes.
Okay. And while we are looking at those transmission, the three that you have indicated in your charter necessary, the J41, J42, and J43, am I correct that SPS has testimony that indicates that even if the commission were not to provide authority to build that particular Gaines plant, SPS is still seeking the upgrade of those three transmission lines, upgrade and or new build for those three transmission lines for other reasons. Is that correct?
Yes, that is my understanding.
Does your understanding go further to tell me why?
Precisely because we operate as a single system, even if the resource were not approved by the state of New Mexico, we would still need to have a transmission network consistent with the integrated transmission plan studies of the Southwest Power Pool. So the RTO also has studies that impact the requirements for our transmission network. I highlight that Mr. Jared Cooley is our witness on the policies of the SPP and these transmission studies and requirements of these transmission studies.
Okay, and I will just ask you briefly, and you can refer me to Mr. Cooley, Mr. Rodriguez, if you want. I mean, I note at page 22 of your testimony, you know, you start to distinguish SPS from other New Mexico utilities, and you do say that SPS is a member of the Southwest Power Pool. And then you further define that, or I'm seeing this as a further definition. At line 10, you say SPS is a load responsible entity, or LRE, within the SPP, meaning it must comply with the SPP's planning policies and must have sufficient generating capacity to serve its peak load. That was your testimony, right, sir?
Yes.
So my question is this: are there other kinds of members in the SPP other than LREs? And if so, what are they?
There are customer groups. There are advocacy groups that are members of the Southwest Power Pool. The load responsible entities are generally the integrated utilities that are regulated and required to provide service with their obligation to serve consistent with state laws.
Okay. And then you're going on in the next page. Answering the question posed at line 13 and 14 of page 22, please describe the Southwest Power Pool capacity requirements that SPS must comply with. And I want, and then you're referring to Miss Lisa's testimony. And then on page 23, line 2, you say SPS submits its capacity position, comma, including supporting documentation, comma, to the SPP on an annual basis for validation and approval. Unlike other New Mexico electric utilities, SPS has an obligation to meet the SPP's PRM requirements, comma, and these requirements are enforced by significant deficiency payments that are designed to equal at least the cost of adding new capacity to cover any deficiency. And then you refer to Mr. Cooley. That's your testimony?
Yes.
So you submit this information on an annual basis, correct?
Yes, for performance-based accreditation purposes, as well as other requirements of the power pool.
And so do you track how close you get?
In terms of, I'm sorry, I'm trying
in
to
terms of your
understand.
position, you submit your position on an annual basis. So do you keep track of, oh, well, we were off by, by this percentage, or we were right on the money on our capacity position, or?
Yes, we track that historically, and the Southwest Power Pool does track it as well. The capacity position is to assess the accreditation of the resources every year so that you can assess how a particular plant performs, and then the public power pool can evaluate the available capacity position of all of the resources available in the Southwest Power Pool, some of which benefit and serve us in when we are in need of resources, and some of which we provide to them when they are in need of generating resources. But
Well,
again,
go
ahead.
Mr. Cooley, sorry.
Yeah,
so is it fair to say then that both SPS and the SPP are not just looking at this capacity, or on a fixed basis, that they're continuously looking at the resources that SPS and the other LREs are contributing?
Yes. In fact, that is what drives the reasons and evaluations that the Southwest Power Pool's Regional State Committee evaluates when establishing a planning reserve margin, for example, as well as assessing even the deficiency payment conversation that we had earlier, which are meant to compensate those other load serving entities in the Southwest Power Pool that provide resources when a particular entity does not have resources to serve its own load.
And is that particular potential deficiency payment based on a one-time or size deficiency, or is it based, if on, oh, well, they didn't have sufficient capacity for this quarter? Can you give me any more specifics on how that's actually calculated and over what time period?
It would be over a various time period, generally looking back over a time frame. Again, the risk comes in that, let's say a load serving entity does not have enough transmission lines capacity to be able to bring in the load. Now you start to impact the operability of your system, which could result in rolling blackouts. So the deficiency payments are meant to compensate those other entities for providing power, but it never supplants the fact that you need to have the capacity, the quote unquote pipeline, to bring that power in order to serve the growing load in a region.
It seems that there's been much made of the PRM requirement for winter over increase to 36%. Does the 15% summer PRM change?
Yes, it rises to 16%.
Okay. And currently the winter PRM is 20.
I will need to evaluate the current number, but it is much lower. And I
It's
do not want
much
to
lower
mistake
than 36.
Yes.
Is that what you mean? Okay.
Yes. The Southwest Power Pool contemplated a much higher winter planning reserve margin with proposals that included numbers in the 40s. The Regional State Committee of Commissioners ultimately settled on the 36% winter planning reserve margin.
And your testimony in page 24, beginning the question posed at line 4, does SPS's geographical position in the SPP present unique challenges? You answer yes, and then you're telling us why, and then you go on and continue that answer on 25. Is the import of this testimony that the importance of the testimony is that if you can't import the power, then you're going to have to build it.
That is correct.
And produce it yourself.
That is correct. However, I note that we are required to be able to serve our native generating load in our service territory. The challenge comes in that whereas other utilities could be in the middle of a regional transmission operation system and be able to import power from various directions, we are only able to import power from the north, given our geographic position within the Southwest Power Pool, as well as the fact that we are not part of the Western interconnection and do not operate on the same electric frequency that our colleagues at Planning Public Service Company of New Mexico and El Paso Electric Company operate at. Aside from the generation issues, there are transmission issues that these generating resources address as well. That was the purpose of my testimony.
Yeah, and I think with also when I was looking at page 34 of your testimony, answering the question at line 6 and 7, how will the self-build project transmission network upgrade proposed help address load growth? That seemed to have a geographical context also, and it seemed like to me that in the real estate parlance, it was location, location, location. Is that kind of what's happening in both of these questions?
Yes. However, I also note, and I defer to my engineering experts, given that I am not an engineer, but having the spinning mass resources provides stability to the electric grid, given the high load demand that is in Southeast New Mexico in that location. So that is aside from the challenge of having to import power generally, there is also the additional benefit of having spinning mass that stabilizes the grid adjacent to where the load is high.
And you begin on page 26 talking about the unprecedented, I think you characterized it, growth in your service territory in New Mexico. seems like I saw somewhere in the testimony, you're projecting like 25% increase?
I don't know the specific number to which you're referring, but I highlight that we have the load requests that we saw in 2021 continued the following year, and then the following year, which prompted our integrated resource planning timeline. And we have continued to see load growth in our service territory on a consistent basis.
Okay, and I know on page 28 of your testimony, when you're referring to SPS witness, Mr. Goodenough,
Yes.
you know, you say SPS is now forecasting that its system level peak demand will grow at an average rate of 3.4, and let me read it correctly here, will grow at an average annual rate of 3.4% from 2024 through 2043.
Yes.
Is that correct?
Yes, that is in my testimony.
And you say that's primarily driven from expansion of electrification of oil and gas activities in Lee and Eddy counties and the addition of data center loads in Texas. Correct?
Yes.
That's I've been looking at line 7 through 10. And then I have a question about line 11. Oil and gas production in the Delaware Basin continues to grow. I'm used to hearing about the Permian Basin, but where's the Delaware Basin?
Delaware Basin is a sub-basin of the Permian Basin that is primarily located in New Mexico, specifically overlapping with Lee and Eddy counties in New Mexico.
Okay.
As I understand it.
Okay. So part of the growth is Lee and Eddy County, but you've also included in here in your testimony that part of the additional growth load is actually in Texas.
Yes. Our system is growing across Texas and New Mexico, with New Mexico driving a substantial amount of the load.
And I didn't quite understand this when you were asked about it before, so I'd like to see if you could help me. I'm looking at page 33 of your testimony, and you're continuing to answer the question posed at page 32, line 8 and 9. How does the SPP's interconnection process affect SPS's planning process? And the lines 8 and 9, you say 7 of the 8 proposed self-built projects in this case will be interconnected via the surplus interconnection process. Can you define what that is to me?
Yes, and again, defining subject to my subject matter experts with further detail. The surplus interconnection process is when you can utilize an existing interconnection for your generating resource, meaning that if I have, for example, 100 megawatts that can be interconnected to the grid, and I have a nameplate 100 megawatt generating facility, but its accredited capacity is only 75 megawatts, I have the ability to add another nameplate generating resource to fill that void of the 25 megawatts for which I am authorized. So the term surplus is a term of art that is not necessarily mean extra or unnecessary. The term surplus means that you can add an additional generating resource to fill the void that the nameplate resource does not fill at that interconnection point. Please let me know if I need to provide further detail, but it would be the equivalent of being able to put a wind resource, which you would call surplus, at an existing interconnection point where there is a dispatchable gas resource. And the moment that the wind resource, let's say that the wind starts to stop and the wind facility is no longer providing power at that interconnection point, you can dispatch your dispatchable unit to provide power through that interconnection point.
And there's no additional review or authorization needed to utilize that surplus interconnection process?
I would need to assess whether it is still subject to the specific DICES interconnection process that I defined, but it is still subject to interconnection assessment by the Southwest Power Pool rules. It is a quicker process than the greenfield generation interconnection process, as noted in my testimony at that point.
Is that the 7-year process?
That process has taken 7 years and it is improving, but it still is delayed from its original intent.
Okay, and I just want to identify this for the record. I think you were asked some questions about what is SPS seeking, and with regard to the REA 2045 zero carbon requirement. You address that on pages 43 and 44 of your testimony?
Yes.
Very well, sir. That's all the questions that I had for you. Ms. Hardy, any redirect?
I do have just a couple, Madam Examiner.
Hey, hang on one second. Ms. Drake, did I forget you?
No, ma'am, and I will wait till after the redirect, but I did want to ask if I could have a few minutes for some follow-up questions, and I'm happy to take that time from my time for later witnesses. But I'll wait until Ms. Hardy does her redirect.
Okay. Go ahead,
Thank
Ms.
you.
Hardy.
Thank you. Mr. Rodriguez, Mr. Stoffel asked you questions about the capacity benefits of renewable resources and specifically regarding the Sandy Loam RPS 2030 project. Do you recall those questions?
Yes.
Specifically with respect to the Sandy Loam project, was that project procured solely for RPS compliance?
Yes. The project would not have been selected but for RPS compliance.
And Ms. Amer asked you a number of questions about deficiency payments to the Southwest Power Pool, and specifically why it's reasonable for customers to be responsible for those payments. Do you recall those questions?
Yes.
Does SPS plan its system on a long-term basis?
Yes.
Why?
We recognize that we have to plan a system for a period of time because our customers and our communities we have to meet the expectations of those communities for resources that sometimes take a long-term time to plan for and a long time to build. The Also, the lives of those resources is expected to last, in many cases, decades. An abrupt change in a planning reserve margin may require us to procure additional resources, but those resources, it would not be prudent for us to forego our long-term planning process. The deficiency payments that occur are done to compensate those other entities in the Southwest Power Pool that are helping meet the need for the generating resources that would need to have been built in a particular service territory. It would be imprudent for a utility to immediately try to build a resource at a cost that is unfounded just to meet a short-term planning reserve margin change. That is why the deficiency payments are done to compensate those other utilities and would be a prudent practice under those unique circumstances.
And does SPS conduct its long-term planning in accordance with the commission's rules?
Yes.
Chair Aguilera asked you some questions about detrimental impacts to New Mexicans if large customers are unable to interconnect to SPS's system. Do you recall those questions?
Yes.
If large customers cannot interconnect, could they continue using diesel generation?
Many of them may. Many of them will.
And does that result in increased emissions?
Yes.
If customers were to build their own generation, would the construction activity also result in increased emissions?
Yes.
Thank you. Those are all of my questions.
Thank you, Ms. Hardy. I'll go back through any, and I apologize, Hearing Examiner Schaefer. I forgot to ask you if you had questions.
I did have a few questions, yes.
Go ahead, sir.
Thank you, Mr. Rodriguez, again for being here with us today. I wanted to ask you if you could briefly describe at a high level the company's intention or framework for recovering these costs from New Mexico customers if all the requests were approved.
Yes. Good morning, Hearing Examiner Schaefer. We follow New Mexico law and would go through the evaluations for prudency of our execution in construction of the resources and seek recovery consistent with the recovery mechanisms in either a New Mexico rate case or any other proceeding for which cost recovery would be authorized.
Okay, well, maybe we could provide a little bit more detail. There's testimony in the application regarding certain structures or mechanisms that the company is planning to rely on with respect to cost recovery. And I wonder if you can just describe that for us in a summary fashion.
Yes, for certain renewable resources, if there is recovery under the RPS, Renewable Portfolio Standard, then we would utilize that cost recovery mechanism. We would also go through a standard New Mexico rate case. And of course, if there were any other changes in law related to the recovery of costs in New Mexico, we would follow those as well.
And do you have any thoughts to share regarding some of the mechanisms described in the application regarding the tax credits and how that will affect cost recovery?
Yes, one item is to highlight is that there are production and investment tax credits that are still available as they expire under the One Big Beautiful Bill Act that was passed by the federal government. As we are able to utilize those tax credits by building these resources in a timely fashion, we would then be able to have those credits passed on directly to customers because the costs of building these resources would be much less than they otherwise would have been if the projects are delayed and the tax credits expire under federal law.
And what is the relationship between the SPS rate case that's 25-00079 and this case with respect to cost recovery?
As I understand, given the timeline of the resources that we have in this proceeding, the resources that we are seeking approval of in this proceeding are not within that rate case. The timeframes do not fully overlap.
Thank you, Madam Hearing Examiner. Those are all my questions.
Are we sure that one of the projects wasn't included in the future test year?
I'm looking at the timelines, Madam Hearing Examiner, and I was about to refer to the application and the direct testimony in the rate case, which highlights the timelines. I apologize, Hearing Examiner Schaefer. I may have missed that timeline.
No apologies necessary.
Do you know whether or not the PPAs that Hearing Examiner Schaefer is hearing in the other case, whether or not those have also been potentially included in SPS's pending rate case?
I would need to check those, Madam Hearing Examiner. I also highlight that we do have some projects from the previous request for a CCN from the state of New Mexico that will be in service and are part of that case. So there are new generating resources that are part of the rate case, but those are from the preceding CCN that we received approval of at this commission.
Why don't we consider that a bench request, Ms. Hardy? I'd like to, I think Hearing Examiner Schaefer and I just would like to see in black and white whether or not any of the projects or related projects, referring to, I believe, Mr. Rodriguez has already testified, the PPAs are resource inclusion, and then the transfer, build to transfer. So if you'll include in the bench request exactly what projects related to our 66 case might be included in the pending 25-00079. Hearing Examiner Schaefer, anything further, sir?
No, just also on that point, the 25-00085 case, those numbers. So thank you. That's all for me, Madam Hearing Examiner.
Okay. And 8.5 being the PPA case.
That's correct.
Very well. Did you have a follow-up on that, Ms. Hardy, on our questions we just asked?
No, I don't. Thank you.
Okay. I'll go back and see. I know LES has a few questions based on the questions that I asked, the redirect or the Hearing Examiner Schaefer questions. And Ms. Drake has offered to take time from another witness. Go ahead, Ms. Drake.
Thank you, ma'am. And I just want to clarify what I want to ask is a follow-up to Commissioner Aguilera's exam, if that's okay.
Yes, go ahead.
Thank you. Thank you. Good morning, Mr. Rodriguez. Good to see you.
Good morning, Ms. Drake.
So Commissioner Aguilera raised with you the prospect of larger, sophisticated customers seeking to perhaps self-supply or supply from other sources other than SPS. Do you recall that?
Yes.
Yeah, okay. And would you agree that such customer-specific arrangements could help to reduce SPS's overall system needs?
Not entirely, Ms. Drake, because we must remember that there are also existing generating resources that are retiring. And the new resources are being requested in order to compensate for the generating resources that serve existing customers and existing load that is either well past its useful life and fully depreciated and no longer part of the system, or is inefficient. And so that is the basis, among others, for why we are bringing this case forward.
Understood, understood. But if you had customer-specific arrangements that could supply specific large customers, wouldn't that help to reduce your overall system needs?
It is possible, but I want to highlight that the loads and resources table that we have today is for resource requests that customers have that are well beyond or would not necessarily be supplanted by those large customer arrangements. We, of course, are willing to explore some of them. They may diminish the curve or the magnitude of demand in the future, but it does not fully diminish the demand that we have today.
I understand, but would you also agree that the sheer magnitude of the need and the proposed resources is one of the key concerns in this case?
While I recognize that it is a key concern, the need is been justified and has driven the integrated resource plan process that we have gone through, and is being shown to be increasing throughout the country and not just our specific service area.
Understood, but it is a big concern in this case, is it not?
Yes, I recognize that it is a big concern.
And are you aware that any large customers have sought to work with SPS to develop such resources, either self-owned or owned by SPS and used to serve specific customers? Are you aware of that?
I am also aware of the new laws in New Mexico that help enable that type of work that was referenced in earlier questions.
Okay, thank you. And are you aware that some large customers, including LES, have been trying for, I would say, a few, if not several years, to work with SPS to develop such resources? Are you aware of that?
I'm aware that we have a continual engagement and explore those various opportunities, yes.
Okay, so why has SPS chosen not to pursue such arrangements with large customers that could help to alleviate the magnitude of need and proposed resources we now face in this proceeding?
We have enabling legislation now in New Mexico that can help with this, and I look forward to us continuing this conversation, especially as the laws change in the states that recognize the enablement of these types of programs.
I appreciate that, thank you. But my question was, why have you not up to now pursued such arrangements, even though large customers such as LES have been asking for that, at least to work with you on that for years now? Do you have an explanation for why you have not been interested in that up to now?
Well,
Madam Examiner,
What's your objection there, Ms. Hardy?
that I think the question is argumentative, and I think it also states facts that aren't in evidence.
May I respond?
Yeah, Ms. Drake?
Thank you. Well, first, I think it is, I can rephrase it if it's argumentative, but Mr. Fitzhenry's testimony does relate to this, and I can direct you to specific pages, but I think this is an outgrowth of the line of questions. I don't think it's outside the scope. Mr. Rodriguez has admitted that he's been aware of this interest, and I don't think it's an unfair question to ask him why SPS has not pursued such arrangements if he's aware that large customers have been asking for them. Why has he not pursued them?
I'm going to overrule the objection. I don't believe you did answer the question, Mr. Rodriguez. I believe you answered it in a going forward basis. I think this is a historical question. Answer if you know, sir.
I'm not aware of the specifics, except to know that we have not been able to reach a specific area of agreement between us and the customer. However, we do look forward to working with our customers, and we have had agreements that have been reached on various matters with other large customers on different topics.
Ms. Drake?
I think I'll call it at that. Thank you, ma'am.
Okay, all right, so you're -6.
Thank you, Ms. Drake.
Okay, thank you.
Okay, any other party have any recross based upon the either the commissioners or hearing examiner Schaefer and my questions, or Ms. Hardy's redirect?
Your Honor, Nick Stoffel for the NMLCG. I have just a couple.
Go ahead, sir.
Mr. Rodriguez, do you recall your discussion with hearing examiner Hurst regarding the relative shares of the allocation of these proposed resources?
Yes.
Would you accept, subject to check, that the forecasted allocation factors are provided in SPS Exhibit 32, the direct testimony of Alexander Trowbridge, attachment AGT2, page 3?
Subject to check, yes.
And as far as you're aware, those forecasted allocation factors do not reflect the NMLCG's proposed adjustment for any direct assigned resources, correct?
I do not know.
And then you also had a discussion with hearing examiner Hurst around the performance-based accreditation for capacity in SPP. Do you recall that?
Yes.
And at a high level, that means that if resources do not perform as expected, the capacity value they are accredited declines over time. Would you agree with that?
Yes.
Thank you. No further questions.
Thank you, Mr. Stoffel. Any further redirect? Not redirect, recross. Okay.
I have a question.
Go ahead, Ms. Lynch.
Okay, thank you. Mr. Rodriguez, for the self-build projects that could occur out in the field, have you or are you aware that renewables are potentially cheaper longer term than existing fossil fuel, including diesel projects?
No, because it is all subject to evaluation of the accredited value that is ascribed to each resource.
Thank you.
Okay, last call. Any further recross? Hearing none. Mr. Rodriguez, thank you for your time, sir. You are excused.
Thank you, Madam Hearing Examiner and Hearing Examiner Schaefer and Commissioners.
Thank you, Mr. Rodriguez.
Very well. I think now might be the appropriate time for us to have our luncheon break. We'll be back at 1 to continue with SPS's next witness, I believe, Mr. Rosick. And please remember the YouTube stays on. So we will recess until 1 o'clock. Thank you.
Hi, Mr. Lee.
Good afternoon, Judge. How are you?
Good, good. Just wanted to say hello. We didn't really get a chance this morning with some of the things we were trying to chase down. So just wanted to
There
say
was
hello and good to see you.
Good to see you too. There was lots going on. I'm ready when you are, Judge.
All right, very well. Good afternoon. We are back from our lunch and recess. We continue working on the Dropbox issue, and looks like we have more people that need back in. Very well. Miss Hardy, you have another witness.
I think they capitulated, Judge.
Okay. Oh, there she is. There you go, Miss Hardy. Lost you there for a minute.
Thank you for letting me in.
You have a witness.
We do. SPS's next witness is Mr. Parker Rozek.
Good afternoon, Mr. Rozak.
Good afternoon.
Mr. Lee, would you please swear the witness?
Mr. Rozek, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Miss Hardy.
Thank you. Good afternoon, Mr. Rozek.
Good afternoon.
Can you please state your full name for the record?
Yeah, my full name is Stanley Parker Rozak.
By whom are you employed and in what capacity?
I'm employed by Xcel Energy Services as the Senior Manager of Transmission Line Engineering.
Do you have in front of you a document that's marked as SPS Exhibit 25?
Yes.
Can you please identify it?
It's the direct testimony of S. Parker Rozak on behalf of Southwestern Public Service Company.
Was that testimony prepared by you or under your direct supervision and control?
Yes.
And are there attachments to that direct testimony?
Yes.
And were those attachments also prepared by you or under your direct supervision and control?
Yes.
Are the answers in your direct testimony true and correct?
Yes.
If you were asked the questions in your direct testimony today, would your answers be the same?
Yes.
Madam Examiner, I move the admission of SPS Exhibit 25.
Any objection to what's been identified as SPS Exhibit number 25? The direct testimony of Mr. Rozak as affirmed by him here today. Hearing no objection, SPS 25 is admitted.
Thank you. Mr. Rozek, do you also have in front of you a document that's marked as SPS Exhibit 26?
Yes.
What is that document, please?
It is the rebuttal testimony of S. Parker Rozak on behalf of Southwestern Public Service Company.
And is your rebuttal testimony true and correct?
Yes.
Was it prepared by you or under your direct supervision and control?
Yes.
If you were asked the questions in your rebuttal testimony today, would your answers be the same?
Yes.
Are there any attachments to your rebuttal testimony?
No.
Thank you. Madam Examiner, I move the admission of SPS Exhibit 26.
Any objection to what's been identified as SPS Exhibit number 26? The rebuttal testimony of Mr. Rozak. Hearing no objection, SPS Exhibit 26 is admitted.
Thank you. I have no further questions for Mr. Rozek. He's available for questions from the parties and Your Honor.
Very well. Thank you very much. I believe that the intervener who had reserved time for questions for Mr. Rozak, Ms. Beatles was WRA, and I believe that you reserved 10 minutes.
Yes, that's correct. Can you hear me okay?
I can. Go ahead.
Thank you. Good afternoon, Mr. Rozak. I'm Sydney Beatles. I represent Western Resource Advocates.
Good afternoon, Ms. Beatles.
It looks like your rebuttal testimony primarily focuses on the recommendations of our witness, Nick Miller. Is that right?
Yes, that's correct.
And his first recommendation was that the substations that are included in the gains-related transmission projects be expandable. Is that right?
That's correct.
And what are those three substations?
Those three substations that he identified would be Sidewinder, Andrews County, and the Hobbs generation substation.
And how do you name your substations, by location?
Generally, yes. There's a committee as well to determine names so that we can make sure that neighboring utilities or other aspects don't have a similar name, or that the same name gets named in the same substation, so there's not confusion for operations, things like that. So,
And are there substations at either end of the three new 345 kV lines that are being requested in this case?
yes.
So for example, the Andrews to Sidewinder transmission line includes a substation, the Andrews substation and the Sidewinder substation.
Yes, the line connects those two substations together, correct?
That's how it works.
Yep.
And then there's a line from Sidewinder to Hobbs that you're requesting, right?
Correct.
And then another line from Andrews to Roadrunner, is that right?
Yes.
And you testify on page 4 of your rebuttal that all three of the substations, Sidewinder, Hobbs, and Andrews, already have expandability. Is that right?
Yes.
So does that mean that the initial design of the layout of each of these substations already accommodates any bus work that would be needed in the future?
So yeah, yes and no. So we have to build out the entire ring, and so there may be a position available on the ring of the bus. But we're not going to build an additional ring that won't be utilized today. So there may be space to move the substation fence and build out the substation larger and expand it. So some of the facilities may exist like the bus, but other facilities won't exist today.
But they could accommodate any bus work that's needed in the future?
Yes, that's correct.
Okay. And it might be interesting and helpful if you explain what bus is.
Sure. The bus is the components of the substation that carry the electricity from the transmission lines around the substation through the breakers and the switches and things like that.
So back to the expandability of each of these substations. What about any, Mr. Miller refers to them as civil works that would be needed in the future, such as fencing, roads, drainage, etc.?
Yeah, so typically when we build out the substation, so maybe to use Sidewinder's example, since it's a new substation would be easiest, we'll build out the substation to accommodate the electrical facilities needed, as well as drive aisles, access, things like that. One side of the substation typically then the fence can be moved further out and additional grading can be done in the future if more connections are needed and we have the space and the land available. So we typically only do the minimal amount of work required for the project at hand.
But they are expandable again.
Yes.
Future needs, to meet future needs.
Yes, that's correct.
And what about what Mr. Miller referred to as protection and control enhancements? His example was SCADA, SCADA.
Yeah, so the control house, or commonly referred to as the triple E, the electronic equipment enclosure, is likely what he is referring to. And so what we do is design the control house to accommodate the master plan of how many connections we would plan at the substation. So there's space in the control house to add those connections in and use the system protection and controls that he's referring to.
Mm-hmm. And please refer to page 5 of your rebuttal testimony. And starting on line 4, you refer to the Hobbs substation, saying it's a very congested area, therefore it's generally not a good candidate for additional line connections. Is that a fair restatement of your testimony?
Yes.
And that other technologies such as reactive compensation could be considered at the for installation at the station if necessary. Is that right?
Yes.
So can you describe, first of all, can you describe what reactive compensation is?
Yeah, it's control devices to support the power flow on the grid, either the voltage or the frequency.
And is that how it compensates for a possible additional line connections?
Yes, that's correct.
What would be involved in your company's determination of whether reactive compensation would be needed in the future?
I don't think I can really answer that question. It's probably a better question for Mr. Jared Cooley, because it's really more a planning determination of when it's needed than in engineering would then execute the plan. But he'd probably be able to answer that question better.
Okay, and your statement that technologies such as reactive compensation could be considered if necessary on lines, sorry, I scribbled over my line numbers, on lines like 6 through 7 of your testimony on page 5. Would you agree that that is generally consistent with Mr. Miller's recommendation that substations be expandable for possible reactive compensation in the future?
Yes.
Okay. And back to the expandability of these substations. Does that mean that they will include additional breaker positions for possible substation reactive compensation in the future?
Yes, so there's positions available at these substations that could be used for new lines, capacitor banks, StatComs, other devices, new generation connect, things like that. So the position is agnostic to what gets connected to it today, but when the plan becomes into fruition, then we will use the positions that are available in the expandability for that need.
Page 6 of your rebuttal, please. I just would like you to clarify what you're referring to on line 3 by use of the word available. You say the control protection enclosures are specified with enough space to accommodate the future expansions available.
Yes, so as I noted earlier in my rebuttal testimony, there is a space available at Hobbs, Sidewinder, and at Sidewinder for expansion. And so what I was saying is that the triple E, the equipment enclosure, has space available to accommodate those additional connections that we have space for at those substations.
Okay, I was So you're not using the word available as limitation of like the future expansions.
Correct.
Okay.
You got a minute.
I am going to, I would like to borrow some, not borrow, take some time from, let me see, I'll leave it with, from like 10 minutes from Ms. Lee's, please.
Okay.
Thank you. Okay, moving on to page 7 of your rebuttal. Lines 10 and 11, you state that Mr. Miller, he contends that these technologies will improve power density of existing lines to avoid continued transmission construction and associated public pushback. Do you see that?
I do.
First of all, for the record, let's be more specific about the technologies that you're referring to in your testimony. Are these the grid enhancing technologies?
Mr. Miller referred to dynamic line rating DLR, grid enhancing technology.
I'm sorry, sir.
Oh,
Mr.
sorry.
Miller referred to,
Yep.
you said it just too quick, dynamic line.
Yep. Mr. Miller referred to dynamic line rating, DLR, grid enhancing technologies, GETS, and flexible AC transmission system technologies, FACS, in his testimony.
Okay, and when you say, when you are referring to that, his contention that these technologies will improve power density of existing lines, by referring to existing lines, do you mean the 3 new 345 kV transmission lines that you're proposing in this case to support gains?
I don't think I can say what Mr. Miller was referring to, whether these lines or other lines already on the grid, or both.
Oh, so you're quoting from Mr. Miller's testimony.
Correct.
Thanks for that clarification. And moving on, and Mr. Miller provides additional reasons to improve the power density of these lines. Is that correct? Like not just construction and associated public pushback, right?
He does.
So he makes his design recommendations with the specific intent or goal of enabling variable energy resources, i.e. wind and solar, to connect quickly and at low cost. Would you agree?
Yes.
Moving on to page 8 of your rebuttal testimony. Starting on line 8, you state that SPS has considered all of the technologies Mr. Miller identified and either included them in the design for the new facilities or determined that the technology would not be a prudent investment at this time. Do you see that?
I do.
Does that include advanced conductors?
Yes.
So that technology is included, I believe you testified. Is that right?
Yes.
And what about GETS, FACS, FACTS, or DLR? Are any of those included, or you just determined at this time that they're not prudent yet?
They are not included at this time.
And when you say that you've considered all the technologies Mr. Miller identified, what is involved in that consideration?
So that'll come out of the planning studies. So you may get a better answer again from Mr. Cooley. But the planning studies will look at the best ways to bring the generation or the load onto the grid and determine what upgrades are needed to appropriately control the system and provide the power where it needs to go.
Could you refer to Mr. Miller's testimony on page 16?
Of Mr. Miller's?
Yes, please.
Okay.
And thank you for that referral to Mr. Cooley.
Yep.
And could you look at lines, well, tell me when you're there.
Yep, I'm ready.
Okay, and could you look at his lines 7 through 11, where he recommends that SPS document, perform an engineering design study in the previous paragraph to evaluate DLR, and that SPS should document system benefit findings, including incremental power transfer capability for the lines, as well as reductions in required reactive compensation, line ROW, I presume that's right away, and heights, visual impact, and any reliability benefits or cost associated with the advanced designs. Sorry to read the whole sentence. I'm going to finish it though, including estimates of any incremental capital costs compared with incremental renewable energy delivery. Do you know whether SPS considers any of those elements that are listed on lines 7 through 11 of Mr. Miller's testimony on page 16?
I probably would again point you to the planning studies and Mr. Cooley to get an appropriate response to that question.
Okay, let's move on to page 9 of your rebuttal. And starting on line 11, you state that DLR technology can also be added at a future date to any transmission line if the transmission line begins to limit the circuit rating. Do you see that? Oh,
yes.
And, I'm sorry. I wanted to refer you to the following sentence. SPS generally agrees that SPS and Southwest Power Pool should consider gets and facts in system planning when needed. And my question, that is your testimony, right, on lines 15 through 16 of page 9?
Yes.
My question is, does SPP have any planning policies related to enhanced transmission technologies?
I do not know. Mr. Cooley might be able to answer that question though.
Okay, thank you. And do you understand that Mr. Miller recommends these technologies to support the future integration of clean resources?
Yes.
And do you agree that there are high quality wind and solar resources in the vicinity of Gaines?
That is my understanding.
And let's refer to your last page, 10. And you state, starting on line 5, that as part of the DISIS, DISIS, Southwest Power Pool did identify a fax device that was needed for the DISIS cluster, but with the withdrawal of other GI requests, the fax device was no longer required and removed as a network upgrade. First of all, what does GI on line 6? Oh, generation interconnection, right?
Yes, correct.
That's what it stands for on line 6, right?
Correct.
How easy is it to add facts, FACTS for the court reporter, after the fact?
It's fairly easy. They're usually connected at a substation, and if we have the land available, they can be added to the substation.
And I have a final question, and if you want to refer it to Ms. Lees or Mr. Cooley, that's fine.
Okay.
Assuming that the commission approves Gaines and its related transmission projects, and a post-final order compliance filing that reports the commercial operation date and other details, assuming that such a report is required, would SPS be willing to include which, if any, of Mr. Miller's recommendations were included.
Objection.
Ms. Hardy,
That's outside the scope of Mr. Rozak's testimony.
Ms. Beatles,
Well, he does address Mr. Miller's specific recommendations, and I also provided the opportunity for him to refer it to someone who may have the authority to agree on behalf of the company if he doesn't feel comfortable doing it. But the question is whether the company would be willing to include in any post-final order compliance filing whether Mr. Miller's recommendations were incorporated.
I'm going to sustain that objection because I don't recall Mr. Rozak talking about compliance filings in his testimony. So
Yeah, I'm not saying that he did. I'm just asking. He did address Mr. Miller's recommendations, and I mean, you're not ruling that I can't ask another witness, right?
no,
Okay. All right. Thank you.
that's your 10.
Yeah, and that's all I have. Thank you.
Thank you. I believe that staff also reserved some time for Mr. Rozak. And
Yes.
it looks like to me 20 minutes.
Yes, ma'am.
Go ahead.
I don't think, well, actually, I shouldn't say, if there is a balance, if I would like to move that to Mr. Cooley, please, but we'll see if that happens. Good afternoon, Mr. Rozak. I just have a few questions. If you could please go to your direct testimony, page 14. Let me know when you're there.
I'm ready.
Okay, so on this page, you talk about how the lines J 41, 42, and 43 are transmission facilities, but they have been identified as part of the SPP's generation interconnection process. Is that correct?
Yes.
Just to clarify, how is SPS classifying J 41, 42, and 43? Are they transmission? Sorry, are they transmission or generation interconnection facilities?
They're transmission facilities.
Okay. So could you point us, please, where in the SPP interconnection study documents is J 41, 42, and 43 identified as required for gains interconnection?
I believe that's explained by Mr. Cooley in his testimony.
Okay, another Cooley. Okay. So looking ahead, do you know how SPS is planning to treat these facilities in the next rate case?
I do not.
You do not? Who would know?
I'm not sure. I don't have any involvement in rate cases typically, so I'm not positive.
Okay. And finally, these facilities, do they address the broader SPP system needs beyond the gains interconnection?
I do not know.
Who would know?
I think Mr. Cooley would be able to answer that question.
Okay. Okay, that's all I had. I don't know what the balance is, Madam Hearing Examiner.
You reserved 20 minutes and you used 3.
May I move the balance to Mr. Cooley, please?
Okay.
Thank you. That's all I have. Thank you.
Very well. Don't know if I think the commissioners would let me know if they have questions for Mr. Rozak. I just
None
have
for
a
me,
couple.
Hearing Center.
Pardon me?
None for me.
Very well, thank you, Mr. Chair. I just want to start where, good afternoon, Mr. Rozek, welcome.
Good
Uh,
afternoon.
I just want to start where Ms. Lang left off, and that's by looking at your direct testimony on page 14. And you're answering the question posed at line 14. How did you quantify the total cost of the proposed transmission projects? And you begin your testimony in line 15 with the 4 major components that comprise the proposed transmission project's estimated cost. And you list 3.
It seems we have a typo. It should probably say 3 major
Okay.
components.
I didn't know if one got left out or. Okay, so that should say 3. I also wanted to look at at page 12 of your direct testimony. And you're answering the question posed at line 8, what's the construction timetable for the transmission lines? And begin your answer on line 9, and then you have a table SPW-1, correct?
Yes.
And you have different categories in that table for various things to be done, and it's separated out by 2 of the lines are together, and then 43 is separate, correct?
Yes.
And some of those deadlines have, or projected times have already occurred, correct?
Correct.
So for example, did the engineering start actually in June of 2025?
Yes, that's correct.
And what does an engineering start involve?
For the transmission lines, we need to work with our siting and land rights group on supporting them on right-of-way acquisition and routing, things like that. We'll start doing the preliminary spotting of the structures and preliminary line layout so that we can work with our vendors so they understand, how much conductor we need to order, how many steel poles, insulators, things like that to allow for proper planning, as well as permitting and supporting, this filing as well.
And so all those things have happened?
They have happened or are happening. So I didn't include the end dates. Engineering will be, ongoing. You see engineering complete in 2027. So they're different parts of the project are going to be in different stages based on, where we're at on, different aspects.
And are you directly involved in these 3 projects?
I'm directly involved as the engineering manager. So J41 and J42 are being completed by a consultant for us, and then J43 is being completed by 2 engineers in our Amarillo office. And so I have direct oversight over them, but they're doing the day-to-day tasks and the day-to-day work required to move the thing along.
Okay. And the next category, material order, your table indicates, well, tell me what material order. Is that ordering of materials?
Yes, that's correct. It could be the actual ordering or the reservation of material slots. Some of the material vendors we work with, we have agreements that we can produce so much, steel poles, for example, so much tonnage a month. And so we reserve our space so that we have capacity in the plants to meet our deadlines.
And so that has a deadline of November of 2025. Has that actually occurred?
Some of the material orders would have already started to occur, notably some of the substation equipment. I think Mr. Rodriguez referred to breakers and other long lead time items. Again, we have reservation slots with our vendors, but we have to put those orders in for those really long lead items to have them in time for in-service.
Do you put any of that out for bid?
We have alliance agreements with most of our vendors, so we go through a bid process every 3 to 5 years. It kind of depends on which vendor and the kind of timing, and we work contracts through our supply chain organization to then have the contracts in place, so we don't have to bid every single project. We basically bid them as a group for multiple years, a master service agreement, which is fairly standard in the utility industry due to the continual ordering process that we're going through.
Are you anticipating, based on your knowledge of the process and your knowledge of these agreements, and potentially the availability of the items that you need, are you anticipating any supply chain issues?
Not at this time.
I had one question, sir, with regard to your rebuttal testimony. If you'd look at page 9, you're answering the question posed at lines 4 and 5. What has SPS concluded with respect to implementation of capital D, capital L, capital R on its proposed transmission lines? And then you begin your answer on line 6 as the projects are currently designed, the new transmission lines will not control the circuit rating. That's correct?
Yes, that's correct.
What will?
I don't know the exact elements in the substation, but it'll be the substation elements, whether it's the breakers or switches or other devices in the substation.
So you're differentiating the equipment that's in the substation. There's not any equipment that's on the transmission line itself or incorporated into the transmission line itself?
Yeah, in this case, the transmission line will just have transmission line conductor that has a rating. When we complete a rating for an entire circuit from substation to substation, you have to take into account all the elements along it, and then the most limiting element then controls the rating to make sure you don't overload anything.
Okay. Thank you, sir. That's all I had. Hearing examiner Schaefer, any questions for Mr. Rozak?
None from me. Thank you.
Thank you. Ms. Hardy, any redirect?
No, thank you.
All right. Any recross based on my limited questions? Hearing none. Thank you, Mr. Rozak. You are excused, sir.
Thank you.
Ms. Hardy, you have another witness.
Yes, Madam Examiner, we do. Our next witness is Ms. Zoe Leeds, and Mr. Larson will present her testimony.
Ms. Hearing Examiner?
Yes, ma'am.
Ms. Hardy's volume is very low relative to everyone else's. I don't know if that's a technical thing that other people are noticing.
Okay.
I would agree, Judge.
Okay, Ms. Hardy, speak boldly. I believe what you said is Mr. Larson is going to present Ms. Lees.
That's correct, Madam Hearing Examiner.
Okay, go ahead, sir.
Thank you. Good afternoon, Ms. Lees.
Good afternoon.
Can you please state your full name?
Sorry, I need to swear the witness.
Oh, yes, thank you, Mr. Lee.
Thank you.
Ms. Lees, would you please raise your right hand? You solemnly swear the testimony you're about to give, the matter not pending, should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
Thank you, sir. Welcome, Miss Lees. Go ahead, Mr. Larson.
Thank you, Madam Hearing Examiner. Ms. Lees, can you please state your full name
Zoe E. Lees.
and by whom are you employed and in what capacity?
I'm employed by Southwestern Public Service Company as Regional Vice President of Planning and Policy and Interim Regional Vice President of Rates and Regulatory.
Thank you. And do you have before you what's been marked as exhibit number SPS2?
I do.
And what is that document?
That's my direct testimony in this case.
And does it have an attachment?
It does.
And do you have any corrections to that testimony?
I have one correction.
And where is that correction in your testimony?
On page 37 in footnote number 4.
Can you please describe what that correction is?
Yep. In that footnote, we have a number. We say this season's PRM was subsequently revised down from 3,190 to 2.981 megawatts. That should be 2,981 megawatts. So instead of a period, there should be a comma.
And is that the only correction that you have to your testimony?
It is, sir.
And if I asked you the same questions today that are in that testimony that's been marked as hearing exhibit number SPS2, would your answers be the same?
They would.
Madam Hearing Examiner, I would move the admission of exhibit SPS2.
Any objection to what's been identified as SPS exhibit number 2, Ms. Lee's direct testimony as corrected by her here today? Hearing no objection. SPS exhibit 2 is admitted. Go ahead, sir.
Thank you. Ms. Lees, do you have before you what's been marked as exhibit SPS3?
I do.
Can you please identify that document?
That is my rebuttal testimony filed in this case.
And does it have an attachment?
It does.
And if I asked you those same questions today that are in exhibit SPS3, would your answers be the same?
They would.
Madam Hearing Examiner, I move the admission of exhibit SPS3, the rebuttal testimony of Zoe Lees.
Ms. Lees, are your answers true and correct to the best of your knowledge?
They are, Madam Hearing Examiner.
Any objection to what's been identified as SPS exhibit number 3, the rebuttal testimony of Ms. Lees as affirmed by her here today? Hearing no objection, SPS exhibit 3 is admitted. Mr. Larson?
Thank you. We have no further direct questions from Ms. Lees, and she is available for cross-examination.
Very well. I believe then the first intervener that has questions for Ms. Lees is the large customer group who has reserved 35 minutes.
That's correct.
Go ahead, sir.
I'm sorry, who said that?
Nick Stoffel.
Thank you. Go ahead.
Good afternoon, Ms. Lees.
Good afternoon, Mr. Stoffel.
We just did this, but for the record, I'm Nick Stoffel, one of the attorneys representing the New Mexico Large Customer Group in this proceeding.
Nice to see you.
Likewise, I have a few topics to discuss with you today. First, as Regional Vice President of Regulatory Planning and Policy, you are responsible for directing SPS's regulatory strategy, filings, and compliance activities across all jurisdictions, correct?
That's correct.
And that includes compliance activities in New Mexico?
That is correct.
And as Regional Vice President of Regulatory Planning and Policy, Are you responsible for decisions regarding how to model New Mexico's policy requirements, like the Renewable Portfolio Standard, in the IRP and RFP bid evaluation process?
I'm certainly consulted on modeling parameters, but those decisions I leave to the modeling experts, Mr. Stoffel, on how to do specific modeling.
And regarding the evaluation and selection process for the proposed self-build projects, SPS approached resource planning on a system-wide basis because SPS serves customers in New Mexico and Texas, correct?
That is correct.
And SPS prepared a multi-jurisdictional baseline portfolio, or MJB, that does not incorporate state-specific requirements like New Mexico's RPS, right?
SPS developed a multi-jurisdictional baseline portfolio, correct, Mr. Stoffel?
And that MJB did not incorporate state-specific requirements like New Mexico's RPS, correct?
That's correct. It was an all-source RFP.
And after preparing the MJB portfolio without considering compliance with New Mexico's existing RPS requirements, SPS then looked at how that portfolio addressed compliance with New Mexico's Renewable Portfolio Standard in 2030, correct?
I don't agree that we didn't consider New Mexico statutory requirements, but we did do a post-selection analysis on the portfolio regarding RPS compliance.
And then SPS added additional renewable energy projects to the MJB portfolio to help comply with the RPS, right?
Correct. 2 projects were selected after the MJB in order to meet New Mexico RPS compliance.
And there's only one RPS project at issue in this proceeding now, right?
That is correct.
And SPS proposes to directly assign that resource to New Mexico, correct?
We do.
And the final preferred portfolio, consisting of the MJB resources and the RPS resource, derives its value from the joint contribution of the resources within it, correct?
Can you state that question one more time, Mr. Stoffel?
The final preferred portfolio, consisting of the MJB resources and the RPS resource, derives its value from the joint contribution of the resources within it, correct?
Certainly, the MJB derives its value from the resources in it. The RPS only project, I believe, derives its value based on the fact that it generates RECs for RPS compliance. And that is the reason that it was selected as an RPS only resource.
You include the RPS resource within the definition of final preferred portfolio, correct?
That is correct.
And looking at your rebuttal testimony, PDF page 9, page 12 of your testimony, beginning on line 15. I guess actually beginning on line 14, excuse me. There you testify that the final preferred portfolio derives its value from the joint contribution of the resources within it, correct?
That is what my testimony says.
In other words, it is the combined performance of these resources that satisfies SPS's planning obligations under the 2023 IRP and Southwest Power Pool's PRM and resource accreditation requirements, right?
Mr. Stoffel, I'm just going to review the question that you're asking, the Q&A that you're asking a question about before I answer. Can you restate your question?
It is the combined performance of these resources that satisfies SPS's planning obligations under the 2023 IRP and Southwest Power Pool's PRM and resource accreditation requirements, right?
Yes, my testimony says that It is the combined performance of the resource that satisfies those obligations under both the 2023 IRP and the SPP accreditation requirements. And under the 2023 IRP, we agreed in the action plan to the best of our ability, make progress towards RPS compliance. So Sandy Loam, as part of that final preferred portfolio, contributes to RPS compliance on behalf of New Mexico.
So the combined performance of these resources includes the energy and capacity from any resources that are proposed to be directly assigned to New Mexico, like Sandy Loam, correct?
The combined performance does include the Sandy Loam project and its contribution towards RPS compliance. Yes, sir.
And the renewable resources included in the final preferred portfolio provide the low-cost energy and renewable energy credits necessary for RPS compliance, right?
That is correct.
And outside of modeling, the extent to which those benefits actually materialize depends on the actual performance of the renewable resources, correct?
Sorry, can you say that one more time? Outside modeling.
The extent that those benefits actually materialize depends on the actual performance of the renewable resources, correct?
And when you talk about benefits, can you just tell me what you're talking about then?
I'm referring to the low-cost energy and renewable energy credits that we were just talking about.
Correct. It depends on the performance of those resources.
So if all of the resources proposed in this proceeding were recovered through power purchase agreements, customers would only be charged based on the actual performance of the resources, correct?
Objection.
What's your objection, sir?
I think the question is vague with respect to the actual performance.
Permission to respond.
Yes, go ahead.
I believe actual performance as compared to the modeled performance, which we just discussed, is not vague, and the witness is capable of answering that question. And it is relevant to this proceeding because it ties back to the NMLCG's recommended performance guarantees for the renewable projects that are at issue in this case.
Madam Hearing Examiner, may I respond?
Go ahead.
Yeah, I think with that clarification as to what actual performance means, I withdraw the objection.
Very well. Answer if you know, Ms. Lees.
Can you state the question one more time, Mr. Stoffel?
If all of the renewable resources proposed in this proceeding were recovered through power purchase agreements, customers would only be charged based on the actual performance of the resources, correct?
My only hesitation, Mr. Stoffel, on answering that question is I guess it would depend on the contract provisions in the PPA, and I am not familiar enough with those provisions to answer the question.
Fair enough. So without addressing the specific contracts involved, under power purchase agreements, the company typically pays only for the power that is produced and sold to the company, correct?
I believe that is correct.
And in contrast, if the self-build projects are added to rate base, the revenue requirement for the fixed cost of the resources does not vary based on how the resources ultimately perform, correct?
The fixed cost for the capital investment to build the resources. That's correct.
Looking at your rebuttal testimony on page 26 of the PDF, page 19 of the testimony, beginning on line 10. In that testimony, you're addressing the performance requirements recommended by the NMLCG, correct?
That's correct. I summarize NMLCG witness Hashliman's proposals.
And you do not dispute that the NMLCG's recommended performance requirements are based on the assumptions SPS used to evaluate the proposed resources, correct?
It appears that they based those recommendations on the assumptions.
And those assumptions impact the economics of the portfolios evaluated, such as the amount of tax credit benefits or zero fuel cost energy for customers, right?
I don't know, Mr. Stoffel, those assumptions were used in modeling these resources for the most cost-effective, reliable portfolio to meet our system needs. I don't know how those assumptions affect the economics, and maybe I don't understand your question.
The tax credits from, for example, production tax credits result in a benefit that reduces the cost to customers, right?
I agree with that.
And the amount of tax credits for production tax credits depends on the forecasted production from eligible renewable facilities, correct?
Ask that question one more time.
The amount of tax credits, production tax credits specifically, from renewable resources depends on their forecasted performance in the company's modeling, right?
The amount of production tax credits that were taken into consideration in the modeling was based on those assumptions.
And you do not dispute that the NMLCG's recommended performance requirements are intended to protect customers, do you?
I don't believe that they are intended to protect customers. I believe that they're intended to put performance incentive requirements on specific renewable energy and storage resources. And I don't know that those result in customer protections.
So my question was, you do not dispute that the NMLCG's recommended performance requirements are intended to protect customers.
I guess the intent is up to witness Hashliman.
Turning to page 28 of the PDF, page 21 of your rebuttal testimony, beginning on line 8. There you describe staff's approach as the opposite of the NMLCG's, correct?
Ms. Lees?
Mr. Stoffel said that we said that staff proposed an opposite proposal.
Approach.
I'm trying to find that in my answer.
Look at line 8.
Thank you, Your Honor.
Thank you, hearing examiner.
You're welcome.
I see that testimony, Mr. Stoffel.
You agree that the treatment of tax credits for rate making, such as how they are returned to customers, is different than the
I'm
performance
sorry, Mr. Stoffel, will you start your question again?
Yes.
You agree that the treatment
of tax credits for rate making, such as how they are returned to customers, is different than the performance requirements recommended by the NMLCG, correct?
I think what I'm saying in this testimony is that staff's approach to
If I can cut you off, my question is not about staff's approach. My question is, You agree that the treatment of tax credits for rate making, such as how they are returned to customers, is different than the performance requirements recommended by the NMLCG, correct?
That's what I was getting to with my answer, Mr. Stoffel. And what I was saying is staff's approach to the rate-related requests associated with PTCs and ITCs and asking that that SPS maximize those net tax credit benefits to customers either by deferring or selling credits is a different approach than requiring performance incentive mechanisms on renewable energy and storage resources in this portfolio.
And how actual tax credits are treated is different than holding the company to the assumptions made in its resource modeling and decision-making, correct?
Yes, but the approach is different. Their approach is not requiring performance incentive mechanisms. And NMLCG is arguing that performance incentive mechanisms should be required here to maximize the benefit of the PTCs and ITCs.
And those two approaches are not mutually exclusive, correct?
I don't believe they're mutually exclusive, but they are different approaches.
So turning it to page 30 of the PDF, page 23 of your rebuttal testimony, beginning on line 4. There you
Yes.
acknowledge that the minimum production guarantees proposed by the NMLCG closely mirror similar requirements from the stipulation regarding 2 SPS-owned wind projects, correct?
Correct.
And those 2 wind projects were also proposed to be added to rate base rather than through power purchase agreements, correct?
That is correct. Those 2 wind projects were SPS built projects.
And you testify that those wind projects were brought forward solely for economic reasons, right?
That is correct.
The economic reasons were the benefits from avoided fuel costs under Excel's Steel for Fuel strategy, is that right?
That is correct.
And benefits for SPS and customers from production tax credits, correct?
That is correct. Those resources were brought forward to realize benefits for customers from production tax credits.
And in contrast, the resources proposed here were selected to meet system capacity and energy needs, is that right?
That is correct.
But you agree that the resources proposed here were selected based on an economic evaluation against alternative portfolios, right?
The resources selected here were selected through a process to build the most cost-effective and reliable portfolio among bids in a competitive procurement process.
And so by cost effective, you mean an economic evaluation against alternatives?
That's correct.
And that economic analysis compared relative costs between portfolios, including energy costs, right?
You'll have to ask Mr. Gable exactly what those comparisons were in the modeling process.
You're aware that the comparisons also included different value streams from tax credit benefits, though, right?
Yes, sir. At a high level, I'm aware of that. Mr. Gable can answer questions specifically on how those were considered in the portfolio selection process.
Turning to page 31 of your rebuttal testimony, if that's the PDF, page 24 is the number at the bottom, beginning on line 11. There you describe New Mexico's aggressive RPS policy that increases over time and the need for renewable energy credits to comply with the RPS. Do you see that?
I do see that.
To the extent the NMLCG's performance guarantees create an incentive for SPS to control what it can so that the renewable energy credits assumed in the company's forecast actually materialize, that supports compliance with New Mexico's RPS, correct?
I don't.
Mr. Larson?
That was a compound question.
Your Honor, did you like me to respond? You looked like you were.
Yes, go
thinking on your
ahead.
own.
I'm just rereading it.
It's a longer question. I don't think it's a compound question. And she already acknowledged that these were incentives proposed by the NMLCG so that the resources would hopefully perform as modeled. So it's just building on that discussion.
Yeah, I don't see that it's compound. It is a longer question that has a foundational premise. I'm going to overrule the objection and ask you to answer if you know, Ms. Lees.
I'm gonna have to ask Mr. Stoffel to ask the question again.
Of course. To the extent the NMLCG's performance guarantees create an incentive for SPS to control what it can, so the RECs assumed in the company's forecast actually materialize, that supports compliance with New Mexico's RPS, correct?
I disagree that performance incentive mechanisms that NMLCG has proposed here supports RPS compliance. It's my testimony that I think it makes RPS compliance more complex and difficult.
And that's what I'm getting at. So expecting resources to perform as modeled by the company, so the forecasted benefits for customers and the renewable energy credits for compliance with the renewable portfolio standard actually materialize, does not work at cross purposes with New Mexico policy, correct?
I don't know that I agree with that. And I think if we're going to talk about performance incentive mechanisms like the one NMLCG has proposed, and by the way, I've not conceded that they are incentives, they're just called performance incentive mechanisms. If we're going to talk about performance incentive mechanisms like those, I think the right time to talk about those are in the IRP so that we can incorporate such mechanisms or assumed mechanisms in our resource selection process in the competitive RFP.
So looking at page 32 of the PDF, page 25 of the testimony, starting at line 11. It's as if you've read my script. There you argue that the NMLCG participated in the stakeholder process for the 2023 IRP. And the NMLCG never raised the notion of performance requirements for utility-owned resources, correct?
That is my testimony.
Now turning to page 18 of the PDF, page 11 of your testimony, beginning on line 7. There you discuss how the 2023 IRP did not identify individual projects to be assessed in isolation, or even a prescriptive specific set of resource types that SPS must procure regardless of cost or availability. Instead, it provided a portfolio-based framework based on modeling in which multiple generic resource types with generic pricing contribute distinct and complementary operational attributes that together produce a least cost and reliable system plan. You see that?
That is my testimony.
Similarly, the IRP does not distinguish between power purchase agreements and self-build projects, right?
I don't believe that it does. I'd have to go back and double check through section 9, but I believe it provides multiple scenarios based on technology mixes and load forecasts.
And the NMLCG's recommendations here are focused on the portfolio of self-build projects that SPS actually proposes to construct and include in rate base in the future, correct?
That is correct.
And the actual self-build projects would approximately double SPS's rate base. Is that accurate?
Subject to check, I believe that sounds about right.
And the commission does not approve SPS's IRP, correct?
The commission accepts it.
Not approve, correct?
That is correct.
So by extension, the IRP is not a proceeding where the commission can approve performance requirements for utility-owned resources, correct?
No, but the IRP is a proceeding in which the stakeholders come to a consensus on an action plan that shapes the way SPS issues an RFP and evaluates resources in that RFP. And here, the consented to action plan shaped how SPS evaluated resources in the RFP. SPS depended on that consented to action plan in its actions moving forward in following that plan.
Looking at page 33 of the PDF, page 26 of your testimony, lines 4 to 7, there regarding the NMLCG's recommended performance guarantees, you argue that adoption of these conditions may lead to the projects not being constructed. So the record is clear. Is it SPS's position that it will not construct the self-build projects if the commission adopts the NMLCG's performance guarantees?
It's my testimony that we'd have to reassess whether we can construct these projects based on what the commission findings are.
In totality, is that not specific to these performance guarantees, but the overall decision the commission makes regarding the self-build projects?
There are certainly other issues in this case that we have said we would need to reevaluate whether to build projects based on commission finding on certain issues.
Turning to your rebuttal testimony at page 83 of the PDF, page 76 of the testimony. There you respond to the NMLCG's recommendations regarding review of cost overruns, correct?
That's correct.
And generally you oppose the NMLCG's recommendations because they go beyond the requirements of Rule 580. Is that fair?
Yes, it's my testimony that Rule 580 governs how any cost overruns over the certificated costs are treated.
Rule 580 provides that a utility cannot recover cost overruns and rates unless the commission determines they were prudently incurred, right?
That's my understanding of the rule. Of course, I always appreciate the rule being brought up in front of me if I'm going to be asked questions about it.
I believe you quoted in your testimony, but we're not going to get to that specifically. You agree that part of the NMLCG's recommendation regarding cost overruns is to specify the evidence SPS would need to include in support of a request to recover cost overruns, right?
Can you just direct me to where in my testimony you're talking about?
Well, I'm talking about your response to the NMLCG on third-party evaluation of cost overruns. And that is specific to, on page 76 of the testimony, beginning on line 7, if and when costs exceed the category by more than 5%, SPS would be required to retain an independent third-party consultant. You see that part?
I do. Thank you.
So that is really trying to specify the evidence that would be required to support a request for recovery of cost overruns, right?
Yes, I believe I'm summarizing what NMLCG witness Hashlemound's proposal is in the case. And the proposal is, if and when costs exceed the category by more than 5%, SPS would be required to retain an independent third-party consultant to review the cost overrun.
You agree that SPS's proposed portfolio of self-build resources represents a significant investment, right?
I do not dispute that.
And given the magnitude of the investment, cost overruns could also be significant?
Hypothetically, they could. I don't know if we will have significant cost overruns in this case. And if we do, Rule 580 provides a process for the commission to review those cost overruns for prudency before allowing us to recover those costs.
And the NMLCG's recommendation provides a framework and evidentiary burden for what the company would need to show in that future filing, right?
It certainly provides requirements above what Rule 580 requires. I have not seen any evidence in this proceeding as to why the proceeding under Rule 580 does not work as it stands.
Subject to check, 5% of $9 billion is $450 billion or $450 million, right?
Subject to check. I'm an attorney, Mr. Stoffel, as you know, math is not my forte.
I'd like to discuss the NMLCG's recommendation regarding the financing plan for the proposed self-build projects. As part of this case, SPS has requested certificated costs that include an allowance for funds used during construction, or AFUDC, correct?
That is correct. We have a request for AFUDC in this case.
And AFUDC reflects the cost of financing construction of the new company-owned resources, right?
Correct.
And the estimated AFUDC amount included in the proposed certificated costs is approximately 10% of the estimated construction costs, right?
Oh, if you could point me to where that is in testimony, Mr. Stoffel, I just don't remember off the top of my head if that's the figure.
We don't need to chase that one down. But looking at page 86 of the PDF, page 79 of your testimony.
And we're still in my rebuttal testimony?
Correct, correct.
Okay.
So in that testimony, beginning on line 4, you argue that the reality of the NMLCG's proposal is that SPS would have to wait to commence financing for the self-build projects until conclusion of the financing plan case. Is that right?
I agree that's what my testimony says, but can you tell me what page we're on? Sorry, I think I'm on page 89 and I don't see that testimony.
79 of the testimony, 86 of the PDF.
Thank you. I was on the wrong page.
You got a minute left, Mr. Stoffel.
Thank you, Your Honor. I'd ask for your indulgence. I've encountered some slow response time and objections through this cross-examination.
Are you borrowing from somewhere else?
If I could start by borrowing against the 25 minutes surrendered by Prosperity Works and the NMDOJ this morning, I'd appreciate it.
Nope, nope. You can't take theirs.
well-
You have to borrow from your own.
Well, I'll borrow from the future. We'll figure out who as we proceed.
All right, go ahead.
The NMLCG does not argue that construction of the project should be delayed until the
Sorry,
finance.
sir, start the question again, please.
The
Slow down
NMLC
just a little bit if
yeah.
you wouldn't mind.
The NMLCG does not argue that construction of the project should be delayed until the financing plan is resolved, correct?
I did not see testimony in NMLCG's witnesses' testimony that said that, but I think the practical result, if we are required to bring forward a financing plan for approval before financing these construction for these projects, would result in delay.
Reducing the financing costs as reflected in AFUDC ultimately reduces the amount of rate base for the self-build projects, correct?
I agree with that. And Mr. Asmus talks about how the way the company finances itself is the most efficient way to control AFUDC and finance prudently.
Looking at page 90 of the PDF, page 83 of your testimony. There you're responding to the NMLCG's recommendation that the commission cap AFUDC at each project's expected commercial operation date and limit accrual of AFUDC beyond that point to extraordinary circumstances outside the company's control, right?
That is NMLCG's proposal.
You agree that the NMLCG proposes to limit SPS's ability to recover additional financing costs incurred as a result of delays in the projects reaching their respective commercial operation date for reasons within SPS's control, right?
If that's the intent of the proposal, I guess that's up to witness Hasselman to clarify. What I will say is construction timelines on these projects are already very pressured. And we've been clear with the commission that that there are challenges in meeting construction deadlines. And I think the proposal by NMLCG is punitive to SPS and trying to execute on this portfolio.
Turning to the issue of allocating the proposed self-build resources between New Mexico and Texas. SPS seeks approval of its proposed jurisdictional allocation because, in the company's view, that is critical for SPS to allocate costs of the projects and for customers in each jurisdiction to understand cost impacts, right?
Yes, the company is asking for approval of the methodology in order to calculate the jurisdictional allocation of these resources. And I do testify that those are necessary in the way that you described.
As it relates to understanding cost impacts for customers in New Mexico, SPS is not requesting shortened service lives for the new gas resources proposed in this case, correct?
That is correct.
So we do not have information in this proceeding regarding the estimated rate impacts if those new gas resources are fully recovered from New Mexico through 2044, correct?
I don't believe we have that information in this proceeding, although subject to check on Mr. Trowbridge's rebuttal testimony.
And then if those resources are fully recovered from customers in New Mexico through 2044, we also don't have information regarding the cost of replacement resources needed in 2045, correct?
I believe Mr. Gable's testimony provides if we don't have these resources in 2045, what that replacement looks like. And Mr. Trowbridge also provides testimony on what that impact would be in costs.
So in your rebuttal testimony, you raised the concern about parties implicitly moving towards a split of the SPS system. Do you recall that testimony?
I do, and I am very concerned about that.
And on page 78 of the PDF, 71 of your rebuttal testimony, you mentioned Mr. Gable providing more detail about the quote, beginnings of a split of SPS's system, right?
Yes, that's correct.
Are
Page
you
71, lines 4 and 5.
Are you familiar with the Roswell and Chavez power purchase agreements?
I am, Mr. Stoffel, familiar with those two projects.
Those were approved by the commission in New Mexico and rejected by the commission in Texas, correct?
That is correct.
And then the company-owned Cunningham battery proposed in 2023, again, that was approved by the commission in New Mexico and denied by the commission in Texas, correct?
That is correct.
And then rather than incorporating the New Mexico RPS into the baseline resource evaluation and selection, SPS opted to prepare the multi-jurisdictional baseline that ignored New Mexico's RPS requirement and then to solve for RPS compliance after the fact, correct?
I don't agree with that. The multi-jurisdictional baseline portfolio was was done to build the most cost-effective and reliable portfolio in line with the objectives of the IRP rule, which governs how we conduct RFPs in New Mexico, and was in line with the action plan in the IRP that was consented to by parties, that we issue an all-source RFP to select the most cost-effective and reliable portfolio. And parties acknowledged that RPS compliance in doing that would be difficult. After we selected the portfolio, we analyzed whether we could bring part of the portfolio into compliance either through the zero carbon designation or whether we should request exceptions to the Renewable Energy Act requirements.
But you don't dispute that the multi-jurisdictional baseline did not include RPS compliance as a requirement, correct?
We did not force, and Mr. Gable can speak to this, but we did not force the modeling in the RFP bid selection process to select only resources that would be compliant with the 2045 requirement.
And so then SPS added the RPS resources after the MJB portfolio was developed.
Yes, that's correct, Mr. Stoffel. After the MJB was developed, then the projects for RPS compliance were identified in order to help New Mexico customers and the utility meet our Renewable Energy Act requirements.
And SPS decided to propose to direct assign those resources to New Mexico, correct?
Correct. Those resources were selected only for RPS compliance, but for the requirement in the Renewable Energy Act, those resources would not have been selected. Therefore, we've requested to direct assign those resources to New Mexico.
So SPS's system is already experiencing a split between jurisdictions based on decisions made by the Public Utility Commission of Texas and by SPS, correct?
By decisions made by the Public Utility Commission of Texas and by policy decisions that the state of New Mexico has made regarding renewable energy requirements for utilities. I'm very concerned about splitting the system further than the very limited resources you have just identified in your questioning. And I'm concerned about the cost impact that would have on New Mexico.
And you recognize the NMLCG is concerned about the cost impact of direct assigned resources along with the allocation of other system resources, correct?
I recognize that as NMLCG's position, that they are concerned about that. Yes, sir.
Thank you, Ms. Lees. I have no further questions.
Thank you, Mr. Stoffel. You are plus 10, or in your case, minus 10. Mr. Lee, is now an appropriate time for us to take our afternoon break, or shall we carry on?
We can carry on, Judge.
Very well. I believe that the next questioner who had reserved time for Ms. Lee's is OPL. And I believe that OPL reserved 70 minutes.
Your Honor, I don't remember what my overall time reservation was. I anticipate I'll be finished with Miss Lee's within about 15.
All right, sir. Go ahead, please.
Good afternoon, Miss Lees. My name is Michael McMillan. We've met before. I represent OPL. How are you doing today?
I'm well, Mr. McMillan. How are you?
I'm doing pretty well myself. Thanks for asking. So, SPS was aware that it had growing resource needs before it even began the 2023 IRP process, correct?
That's correct, Mr. McMillan, and that's why we requested to start the IRP process a year earlier than we were required to in New Mexico.
Yeah, and in your direct testimony, you identified three drivers of the resource need in SPS's territory, which were increased load growth, increased SPP reserve margin requirements, and impending retirements of aging thermal units, correct?
Correct. Those are the three main drivers of our need.
Okay, so let's talk about load growth first. So SPS has been aware since at least 2021 that there was an uptick in interconnection requests in its service area, correct?
Mr. McMillan, I believe that's correct. I believe Mr. Cooley can speak to the timeline of those interconnection requests. We certainly in 2022 saw an increase in those requests, and I think I outlined that in my testimony.
And you discuss in your direct that the source of the load growth is primarily large, high load factor customers, right?
I believe I say primarily large load growth, but I can look at my testimony and confirm. if you have a page that you're referring to, that might make me go faster. I
No,
recommend.
I see what you're referring to, and you kick it over to Mr. Cooley, but I believe you do say large load interconnection requests without specifying. Would you agree that SPS's system is relatively high load factor compared to other utilities?
Yeah, on a high level, I can agree to that. And Mr. Cooley and Mr. Gable certainly can answer questions to that effect in more detail than I can.
Gotcha. So let's talk a bit about the increased reserve margin requirements. So there you're referring to the SPP PRM requirements, correct?
Correct. The Southwest Power Pool planning reserve margin requirements.
And when did SPP begin discussions about increasing those the summer and winter reserve margins?
I don't know exactly when they started those discussions, Mr. McMillan. Mr. Cooley or Mr. Gable can provide you more detailed information about the discussions at the Southwest Power Pool regarding those requirements.
Okay. And let's talk just briefly about the last one. SPS is known for a while now and including and has made multiple filings with the commission about retirements of its aging thermal units, correct?
SPS has made filings regarding the retirement of aging thermal units. Yes.
So I want to talk very briefly, and I know we're both lawyers, so I'm going to keep it high level, and hopefully we can both be on the same page about some engineering stuff. Are you aware, just conceptually, the difference between a combustion turbine or CT and a combined cycle gas turbine or CCGT?
I'm aware of some of the differences. I am not the subject matter expert that can answer your questions in detail about the differences of those technologies, sir.
No, and I'm just trying to set the scene here, so we'll keep it very high level and let me know if I need to ask somebody else. We'll talk to them later. But so generally, a CT or combustion turbine is cheaper than a CCGT or combined cycle turbine on the basis of the capital cost, right?
I believe that is correct, sir. Again, I do not develop these projects. Mr. Gertz would probably know better than I on the pricing of building those technologies, but at a high level, that sounds right.
Yeah, and we'll talk to them about the engineering specifics, but just generally speaking, CTs are cheaper up front from a capital cost perspective, right?
I believe that's correct, subject to check with Mr. Gertz.
And CCGTs have a lower heat rate than CTs, meaning they burn fuel more efficiently.
I understand that. Yes, sir.
Are you agreeing with the understanding that
Yeah.
you're not an engineer? Are you agreeing
Yeah.
with me?
That is my understanding.
So the more that you run a CCGT compared to a CT, the more affordable it is because you're burning more fuel at a better rate. Is that correct?
My only hesitancy is, as I've noted in my testimony, we select a portfolio and the portfolio works together for to provide those economic benefits, the most reliable, cost-effective portfolio. And I am just not familiar enough with how CCs would operate in the context of this portfolio to answer that question.
Fair enough. We can go into that with some other witnesses. So uh, attachment ZEL1 to your direct testimony was the 2023 IRP report, correct?
Yes.
Okay, and that report came out on October 13th of 2023, right?
Correct.
And the IRP process started, I believe was it 6 months prior to that?
Correct. We filed a motion with the commission in March of 2023 to file our IRP a year early, and the facilitated stakeholder process started shortly thereafter.
And during the facilitated stakeholder process, SPS and various stakeholders agreed on modeling parameters, and then SPS modeled various scenarios for the IRP, correct?
That's correct, using a generic set of resources.
And so that modeling process went through a number of iterations during the 6-month IRP process, right?
Yes, sir.
Is it fair to say that SPS was at least directionally aware of what the model was pointing at prior to the final IRP report coming out?
I don't understand your question, Mr. McMillan.
So, for example, let's say a month before the final report came out, SPS had already done multiple rounds of modeling at that point, correct?
That's correct.
So SPS at that point wasn't totally in the dark about where the final report was going to come out, say, a month later.
I believe by a month ahead of filing the IRP, we had done modeling scenarios and had seen some of those results. Yes, Mr. McMillan.
Okay, but focusing back on this final IRP report, that was the end result of the IRP process, correct? The October 13th report?
The integrated resource plan that we filed on October 13th was the culmination of the modeling done during the facilitated stakeholder process.
Do you have a copy of attachment ZEL1, that October 13, 2023 IRP report?
I do.
Can you turn to page 164 of 1687? And just let me know when you're there.
I'm there,
Okay.
Mr. McMillan.
So I'm going to read the first sentence there, and can you tell me if I read it correctly? As acquiring new resources is often a multi-year process, the new resources included in each of the most cost-effective portfolio of resources before the end of the current decade require greater attention. Did I read that right?
That is what the IRP says, yes.
And then below that, it says that the most, pardon me, through the end of this decade, the new resources included in the most cost-effective portfolio of resources under the MJB, and that means multi-jurisdictional baseline, case is shown below in table 9-3. Is that right?
That's what the integrated resource plan says on that page, correct?
Okay, and that MJB, the most cost-effective multi-jurisdictional baseline portfolio identified 837 megawatts of combined cycle capacity as part of the most efficient portfolio, right?
Most efficient portfolio using generic resources with generic pricing.
But it did include 837 megawatts of combined cycle resources.
Yes, that's what the table says on that page.
Okay, so at that point in October of 2023, SPS knew that it was going to submit self-build projects into the upcoming RFP, right?
I agree with that.
And SPS had one site in particular that it had previously identified as a potential site for CCGT, and that was the Gaines site, correct?
SPS had the Gaines site in the DICES queue at that time. That is correct.
And what is the DICES queue? Can you explain that for us?
The DICES queue is a generation interconnection process at the Southwest Power Pool. It studies generation interconnection ahead of allowing the company to build and connect such resources.
And the Gaines location had actually been in the DICES queue since 2020, correct?
I believe that's correct. You'll have to ask Mr. Gertz or Mr. Cooley the exact timing of how long that project had been in the DICES queue.
And as of October of 2023, was Gaines the only potential thermal generation site that SPS had in the DICES queue?
I don't know the answer to that, Mr. McMillan. You'll have to ask Mr. Gertz.
Gotcha.
I don't know whether we have other thermals in the DICES.
So the 2024 RFP, when did that come out?
In 2024, I believe in the summer, and if you give me a minute, my direct testimony gives you the month. In July 22nd, 2024.
And that 2024 RFP, when it came out, it specified that gas thermal projects that required a new generator interconnection agreement had to be at least phase 2 of the DICES process, correct?
I don't think that the phase 2 requirement in the RFP was limited to gas thermal projects, but there was a requirement that Mr. Gable can talk about regarding a DICES position and having it have completed the phase 2 study process.
Yeah, thank you for that clarification. So SPS had a similar requirement for potential generation to be at a certain point in the DICES process in its previous RFP before the 2024 one, correct?
I don't remember. Mr. McMillan, I'd have to look at that RFP to confirm.
And that we don't need to divert off to that, but thank you. Okay, so other than, or excuse me, so given that the Gaines project was in the DICES queue, it's fair to say that to the extent that SPS was going to develop a self-build CCGT, the Gaines site was probably the obvious choice for that, right?
I don't know, Mr. McMillan. I don't develop projects like this, so I can't opine onto what would be an obvious choice for such project development.
Fair enough, Ms. Lees. So, other than developing the RFP itself, to your knowledge, what steps did SPS take to evaluate or advance a potential CCGT project at Gaines between when the IRP concluded in October 2023 and when the RFP came out in July of 2024?
Objection.
Sir?
I think we're getting well beyond the scope of Ms. Lees' testimony in terms of what the steps being taken to develop specific resources are. SPS has other witnesses that were involved in that process.
Your Honor, if she doesn't know, she can just say she doesn't know.
I think in her position, she would probably be poised to have such information, and if not, she she can let us know. So I'm going to overrule that objection and answer if you know, Ms. Lees.
I don't know Mr. McMillan. I was on a technical advisory team in which I could, of course, answer questions regarding regulatory processes in New Mexico for either one of the other teams in that separation protocol, but I was not on the bid development team, so I don't know what specific steps they took between developing the IRP and submitting bids.
Thank you, Ms. Lees. So, to your knowledge, was there anything preventing SPS from taking steps to advance a possible CCGT project at Gaines between when the IRP report came out and when the RFP was issued?
I don't know.
Thank you, Ms. Lees. Your Honor, that's all I had.
Ms. Lees, who would have the answer to that question?
Mr. Gertz.
Thank you. Very well. I think now is probably the appropriate time for us to take our 10-minute break. So we will come back, and I believe the next questioner is LES, who reserved, I believe, 30 minutes.
That's correct, ma'am. Thank you.
Very well. Okay, I've got 2:47 here on the computer, so I guess let's come back at 2:57. Remember, please, that the YouTube is on. Thank you.
Thank you.
Mr. Lee?
I'm ready, Judge.
Very well. Let's go back on our record. We're back from our afternoon read. And cross-examination from LES, who I believe reserved 30 minutes. Please go ahead.
Thank you, ma'am. This is Joan Drake representing LES. We probably won't take the entire 30 minutes, but I'll bankroll that if I could. Good morning. I'm sorry. Good afternoon, Ms. Lees. Good to see you.
Good to see you too, Ms. Drake.
If I could direct your attention to your rebuttal testimony, page 7, and that's my page number. References are to the page numbers at the bottom of your testimony.
Thank you,
So
Ms. Drake.
page 7.
That's helpful because I have a paper copy in front of me. So
Good. So go to, if you could, bottom of page 7, line 17 to the top of page 8, line 1. Let me know when you get there.
Excuse me.
starting on line 16, Ms. Drake.
17. Sorry, 17.
Okay, Ms. Drake.
So you testified there that, quote, the commission should reject proposals that call into question SPS's ability to recover prudently incurred costs in the future, unquote. Is that correct?
That is what my testimony says.
So your testimony here references costs and cost recovery in the future. Is that correct?
Cost recovery of the capital investment we'll be making as part of the portfolio we've put forward in this case.
Right. Okay. Thank you. In this case, so you've requested approval of certificated estimated costs, correct? That's in your list of requests.
We have requested approval of our certificated costs in this case.
Okay. And I would just like to understand at a high level, what is your understanding of what that entails? And I want to be cautious here. I understand you're a lawyer, and I'm not asking you to give your legal opinion. I'm asking you to give your understanding as SPS's vice president, in which role you are testifying here today. Correct? Is that a fair understanding?
I'm sorry, there were a few questions in there, but I do understand that I am testifying in my role as RVP, Ms. Drake.
Great. All right, great. So is it your position or is it your understanding that approval of certificated estimated costs carries with it a presumption that the approved certificated estimated costs were prudently incurred?
It is my understanding that approval of the certificated costs starts the process under Rule 580. In that, if we have cost overruns over the certificated costs, SPS cannot automatically recover those costs, but the commission must find that those were prudent expenditures before recovery. And of course, the commission has the ability to examine prudency of costs in rate cases as well.
Well, thank you for that. I'm not asking you to parse Rule 580. It's not in front of us right now, and I'm not asking you to parse that. But let me restate the question. Is it your understanding, if you do get approval of certificated estimated costs, that carries with it into a future rate case a presumption that those approved certificated estimated costs were prudently incurred?
Ms. Drake, I agree. It carries with it the presumption that those certificated costs are prudent and that the commission can examine those costs in a rate case. Doesn't prevent them from having that examination.
Oh, okay, so is your understanding that it's a presumption that will be considered and maybe rebutted in a future rate case? Or well, let me just ask that, stop there. Is that your understanding?
My understanding is that approval of certificated costs first kicks off the process under 580, but that those certificated costs come with a presumption of prudence in a rate case. And of course, presumptions of prudence can always be rebutted.
So my understanding of what you just said is that approval of a certificated estimated cost is not determinative of prudence. Is that correct?
It's a presumption of prudence.
Okay. And if it's not expressly stated as such in a commission final order, is it nevertheless an implied presumption, even if it's not expressly stated?
I guess I don't understand your question if what is not stated.
Sorry, let me restate. If the commission's final order that approves certificated estimated cost does not also expressly state that it is presuming prudence, if it does not include that, does that presumption of prudence still apply going into a future rate case?
I think the approval of certificated costs approves all of the rights and conditions that are attached to those certificated costs under Rule 580.
Okay. All right. Thanks. Let me move on. If you could look at your rebuttal on page 9. And I would have you, well, that is the start of your section 3, which is SPS's need for generation. Is that correct?
That's correct.
And in that section, this is your rebuttal. You address various parties' challenges to the need for generation, correct?
That is correct.
So if you would look on page 9 at line 13, you testify on line 13 that the overall need for the resources is undisputed. What is your definition of the term overall need?
That SPS has an accredited capacity need, in this case, driven by load growth, reliability requirements of the SPP, and the need to replace aging thermal generation.
So that need isn't at a particular magnitude, or is it? Is it the entire magnitude of need that you have identified?
Sorry, I guess I'm not understanding what your question is.
Let me ask it a different way. If you could actually look on page 10 of your rebuttal at line 4, you testify that this case is about need. And then on lines 9 through 10 of page 10, you testify that the general need is not in dispute. So again, I would ask, what's your definition of general need?
The level of accredited capacity identified in which we need to solution with this portfolio.
Okay, and you say that this is not in dispute in this case?
No, I don't believe it is. I believe parties agree that we have a accredited capacity need.
To the level, the maximum level of need that you have identified?
I think parties take issue with certain drivers, with the PRM, with whether it's prudent to meet load growth, as we've stated it, but I don't see any party saying that SPS does not have an accredited capacity need that must be met.
So you haven't identified any opposition to that at all?
That's my testimony.
Okay, if need is driven by load growth, do you agree that if the load that you projected does not actually materialize, then some of these resources may not be needed?
I don't agree with that. There are three main drivers for these resources, and we have much more load growth beyond just what this resource portfolio solutions. And in fact, we still are capacity deficient at the end of the resource acquisition period. This portfolio doesn't meet all of SPS's accredited capacity needs identified.
Okay, well, let me go on from there. Have you been aware that large customers have been interested in working with SPS to develop arrangements to bring on either self-owned or SPS-owned resources to serve them?
I am generally aware that some customers have interest in those types of arrangements, yes.
Has SPS developed such arrangements or worked with those customers to implement those or develop such arrangements?
We do meet with customers regarding those arrangements. For example, we're engaging with customers regarding possible microgrid solutions. We engage with customers on the Renewable Connect voluntary program for large customers to subscribe to that program. And of course, we're always willing to discuss whether we can partner with customers on arrangements that they're interested in.
So does your assessment of need in this case take such arrangements with customers into account in terms of determining your need or ability to ameliorate that need? And sorry if that's a compound question, I can break it down if you would like me to.
Yeah, I don't understand your question.
Okay. Sure. Does your assessment of need in this case take such arrangements with customers to self-supply or to work with SPS for SPS-owned resources to serve them? Does your assessment of need in this case take such arrangements into account?
The planning we did in this case to bring forward the most reliable, cost-effective resource portfolio was done on a system-wide basis, not on a customer-by-customer basis.
Okay, so I take that to be a no? Is that no, that your assessment of need did not take such arrangements into account?
Maybe I'm misunderstanding what you mean by assessment of need. I'm talking about development of a portfolio. If you're talking about load forecasts, I think that those questions are better asked of Mr. Goodenough.
All right, thank you. I think that's it from me right now. Madam Hearing Examiner, if you could let me know how much time I've got banked.
Well, you took 13 minutes.
Okay, thank you, ma'am.
Okay. Very well. I believe that the next questioner is you, Miss Beatles.
Thank you.
And I think you took 10 minutes.
Yes, that's what I wrote down. I took I've already used up 10 of the 20 that I had estimated for Ms. Lees.
Okay, go ahead.
Good afternoon, Ms. Lees. How are you?
I'm well, Miss Beatles. How are you?
Fine, thank you. So I'm going to ask you my 2 lines of questioning in your role as regional vice president. And you have numerous new load requests from oil and gas industry customers. Is that right?
We do have many new load interconnection requests. We saw a spike in 2022. I think my testimony kind of goes over that, and many of those are from the oil and gas industry.
And how long have some of them been waiting?
Oh, quite a while, Miss Beatles. I think Mr. Goodenough could speak to maybe how we've had to manage those load interconnection requests. I would say 2 or more years.
And there's a difference between companies that have existing operations that they want to power with electricity and those requests for new or expanded operations, right?
I don't know what the difference in those types of requests would be in the load interconnection requests, but they are different types of requests, I suppose.
And I'm wondering whether the company would prioritize one over the other.
My understanding is that we cannot discriminate against customers in similar customer classes. So I'm not aware that we can prioritize certain customers over other customers based on the type of requests that they have.
And this is my ultimate question, based on that line of questioning. And I'm curious, so I'm going to ask you to assume that Gaines does not get approved. I know that's not what you're asking for, but assume that Gaines does not get approved. But all your other resources are. Would the company be able to manage or stage the additions of new load in a manner that avoids any SPP deficiency?
I don't believe we would, but I don't know, Miss Beatles. You'll need to ask Mr. Gable.
Okay. And this last line of questioning refers to your brief response to Mr. Miller's recommendations in your rebuttal, pages 95 to 96. And were you listening to my cross-examination of Mr. Rozek?
I listened to part of it, then I came in here to get ready.
And this question asks you to assume that the commission approves Gaines and its related transmission projects.
Mm-hmm.
And if there is a post-final order compliance filing that requires you to report the commercial operation date and other details, would SPS be willing to include in that report which, if any, of Mr. Miller's recommendations were included?
If the commission approves Mr. Miller's recommendations in this case and would like us to include those in a compliance filing, SPS will.
And what about if the commission just asks you to report on, doesn't necessarily require that those recommendations be met, but just wants to know what you did and didn't do anyway? Would you be willing to include that in the report if the commission so orders?
If the commission finds value in us including that in the report, then SPS will include it in the report.
Thank you. I have no further questions. Thank you.
Thank you, Miss Beatles. So you're +5 now. Okay, I think our next questioner is CCAE, who I believe reserved 45 minutes. Ms. Lynch, Mr. DeSalen?
At this time, I don't have any questions. I don't know if Mr. DeSalen does.
No questions. Thank you.
Okay, what about the 30 for Prosperity Works?
Prosperity Works has no questions.
Okay. Ms. Zerk, I believe Sierra Club reserved 15 minutes.
That's correct, Your Honor. Thank you. If I run over, I would like to take 10 minutes that we have reserved for good enough. And we'll see if I can get this done in 15 minutes and I need to use that.
Okay.
Right?
All right. Go ahead.
Thank you. Good morning, Miss Lees.
Good afternoon, Ms. Deser.
Good to see you.
Good to see you too.
Would you please pull up Sierra Club exhibits numbered 5 and 6 and SPS exhibit 27?
Okay. I have my exhibits in front of me. It's going to take me a minute, Ms. DeJure, to pull up other. Can you tell me what discovery response is?
Yes, I can. So the Sierra Club let's see.
5.
Sierra Club exhibit 5 is response to SC41.
Okay.
And Sierra Club exhibit 6 is SPS's response to 4.3.
Okay, I have those two. And you asked me to pull up one other exhibit?
That would be the SPS exhibit 27, which is the testimony of John Teisling. And I'm just going to reference that. I'm not going to ask you questions about it, but I want to have it. So if I state that he stated something in his testimony, you can confirm that. You don't have to take my word for it, but I'm not going to ask you specifically about his testimony.
Okay, I now have SC41, SC43, and Mr. Teisling's testimony up on my computer and in front of me.
Great, thank you. All right. So I think I'm going to start by asking you to look at Sierra Club's Exhibit 5. And that question asked SPS to provide a copy of the direct testimony of John Jaqueños that was filed in the Public Utility Commission of Texas. And that was in docket 58664, which is the approval of the Texas, of the portfolio of resources, the self-build resources, right?
That's correct. The question that Sierra Club asks in this RFI is requesting the direct testimony of Mr. Jaqueños in that docket.
And if you would look at Exhibit 6, I'm going to just pretty much ask you the question and answer that is in your response to Sierra Club 4.3. You're looking around. I'll wait till you have
Yes.
that. I have a lot of papers too. I know that feeling. Okay, so tell me when you have it. Sierra Club 4-3.
I have that.
Okay. So that question asked you to confirm whether the purpose of John Jaqueño's testimony filed in the Public Utility Commission in docket 58664 was to sponsor a report by John Jaqueños prepared for SPS analyzing the economic impact of the implementation and operation of 12 generation investments located in Texas that are part of SPS's final preferred portfolio of resources. And you confirmed that, correct?
That is what the RFI states, and that is what the response states. That's correct.
Okay, let's get rid of exhibit 6 now, one less piece of paper. All right, so now I would like to go back to exhibit 5, which is, and let's, that is both your response providing me that testimony, and it is the testimony itself, which you provided as an exhibit. And you verified this response to discovery, and you're the sponsor of that exhibit, correct?
This discovery response attaches the testimony of John Jaqueños in the Texas docket 58664, and I am the preparer and the sponsor.
All right, thank you for that. So if you would, let's open up the Jaqueños exhibit and talk about that, if we can do that. Could you go to page?
Excuse me, Miss George, just give us a second, just one moment here. Okay, Miss George, what is the basis of this use of this exhibit?
Well, I wasn't expecting an objection quite so quickly, but I am prepared to respond to that. So let's look, and I had Ms. Lees and everybody else pull up SPS Exhibit 27. So let's start with that. That is.
Excuse me. Before we get there, let's just discuss Sierra Club Exhibit number 5.
And that's the Jaqueños testimony. The purpose of that is that I would like to respond to a couple of allegations in the testimony of John Teisling. This is impeachment material, the Texas testimony, because he testified. This is why I reference Exhibit 27, the testimony of Mr. Teisling. And I'm going to just mention a couple words. On page 5.
Wait a second. I just want to make sure I'm following you closely. So you want to use this testimony from Texas to impeach Mr. Teisling?
Well, there is, if you'll give me a little bit of liberty to explain, I think this will make perfect sense. Yes. So first of all, Mr. Teisling, I have no information about whether he has read the economic benefits of the preferred portfolio in Texas. There's 2 witnesses SPS has. One filed testimony in New Mexico, and it describes the economic benefits of the preferred portfolio to New Mexico. In Texas, Mr. Jaqueños' testimony provides the benefits of the preferred portfolio to Texas. Mr. Teisling tells the commission these are substantial benefits, and they should be considered in determining whether it's relevant to the issue of whether there is a net public benefit. Okay, so bear with me. I know this is going to be a long explanation, but it's going to make perfect sense.
Well,
All right.
let me ask before we continue, if I
Sure.
may. You again are want to use the Texas testimony to impeach Mr. Teisling. Is that correct?
Yes, it is a statement made by SPS, and it's not hearsay. It falls under Rule 801, 11801, and Mr. Jaqueños provided that these are his testimony. Here's what it says: these are substantial benefits.
We're okay. Thank you. We're not getting into the substance of the questioning or the documentation here. I'm concerned because the witness currently before the tribunal or the commission here is Miss Lees, and I'm having trouble understanding the use of impeachment material for Mr. Teisling when Miss Lees is the witness.
So I am simply seeking to, all right, so I can't directly admit it through Mr. Teisling. He's never read it. He's going to object to it. I don't know what he's going to say. I am not impeaching Miss Lees. I am admitting evidence against SPS. They have submitted evidence through their witness, Mr. Teisling, and I'm talking about Mr. Teisling. I'm not talking about Jaqueños in Texas. Mr. Teisling said this is substantial. It is, if it's substantial, that means it goes to the issue of whether it produces a net public benefit, which is part of the CCN, the proof. How do I determine if it's substantial or not if I do not have context? That is a qualitative term, not quantitative. That does not tell you how to address it, yet he testifies that there are substantial benefits. There's no evidence in this record of here. There's no evidence on this testimony.
I think, Miss Joy, I think that it's important to have a good measured give and take with the hearing examiners. And I'll just ask again, did Miss Lees prepare this testimony that you're trying to admit from the Texas proceeding?
She is the sponsor of the testimony. I'm not alleging she prepared it, but I'm not admitting it against her. I'm not impeached. I mean, the testimony is probative on the issues in this case. She's the sponsor of it. And first of all, it's admissible because it's relevant. And even if it's not impeaching, it is relevant to the weight the commission should give to the claim that the $500 million produces substantial economic benefits. Substantial is a relative term. If I give my daughter $100, that's substantial unless she knows I gave my son $2,000 for his Christmas gift. And what this seeks to do is to provide context. So maybe it's not entirely rebuttal, but it is highly relevant to the weight the commission should place on Mr. Teisling's allegation. These are substantial benefits. It does have.
Thank you, Miss Shore. Hearing Examiner Hurst, would you like to share your thoughts?
Thank you, Hearing Examiner Shaver. If there's any relevance to this testimony, then you need to establish the relevance at the time that you try to use the document, which you've indicated is to impeach Mr. Teisling. I don't think it's relevant to, as you've indicated, to Ms. Lee's testimony. And I'd ask you to move on, Mr. Hearing Examiner Schaefer?
Yes, I think that, Ms. Shore, if you're planning to use that as impeachment material, the more appropriate witness would be for Mr. Teisling. And if you have any other questions, please proceed.
Okay, in that case, would it, I would just, she has verified it and indicated it. I just want to lay a foundation then for it. I'm not going to get to the merits. I just want to establish that it's not hearsay. So when I do that again, and try to admit it through another witness, he's not going to be able to answer those foundational questions. So may I do that through Ms. Lees?
You're just trying to establish that it was a document that was part of an application from SPS in Texas. Is that correct?
I'm trying to establish that it shows the total economic benefits that will result from a build out of resources, of which
Yeah,
New
but that's
Mexico.
not the question I asked. That's not the question I asked. We're not discussing the substance of the document right now. We're just determining you're trying to. I'm trying to help you and just understand the nature of the foundation that you're trying to establish.
Sure. I'm trying to establish that it is not hearsay under Rule 11801 of the Rules of Evidence. And to establish that, I just would, the questions is that it is a statement. It was made within the scope of Mr. Jaqueños' employment, that SPS
He's not
manifested.
here. He's not a witness. He can't be cross-examined. It's not even a proceeding here in New Mexico. It isn't even verified that this testimony was actually admitted by another tribunal, nor that it was relied upon or even corrected, or that even this is the authentic version that was offered to the other tribunal. I'm not going to admit it.
Hearing examiner, it was provided in discovery. Zoe Lees verified that this was indeed the testimony that was filed in Texas. And if I use the word that this was impeaching, rebutting, I would like to withdraw that characterization. I think this is relevant. It goes to the weight of the evidence of another witness, which is a very important issue in this case. There's no context for the commission to understand whether how much weight to put on the idea of economic development, 500 million versus what's the total. There's no evidence of that. There's no context.
Okay, so I would also note that the response was under objection from SPS as well. And I just concur with hearing examiner Hurst that Mr. Jaqueños is not a witness here. If you have some question for Ms. Lees regarding her awareness of this or something general to that nature, I think that's permissible. But if you don't, then I think we need to move on to your other questions.
All right, I will move on, but I just want to say one last thing, is that under the rules, a hearsay, it does not have to be admitted as testimony. It has to be their statement. By filing it in Texas, they've asserted this is their statement. So with that, I'm going to move on to my next exhibit. So, Ms. Lees, could you please pull up Sierra Club Exhibit 2, which is Sierra Club 16. Exhibit 2 is Sierra Club 16.
I have it in front of me, Mr. Jor.
All right. So you're the sponsor, let's see, of this exhibit, along with Justin Gable. When you have two witnesses listed as sponsor, are you competent to answer questions about this, or do I have to have him also to respond to this? I mean, why do we have two sponsors? Either one, is it either?
Typically, it's because there's information in the response that each witness is able to sponsor.
Okay. Well, would you be comfortable with me simply reading the question into the response and All right, I'll tell you what then. Let's go ahead and do that. Question 1.6, please identify any reductions in the assignment of system capacity resources to New Mexico customers resulting from the capacity contributions of the direct assigned renewable resources that serve New Mexico jurisdictional customers to comply with New Mexico's RPS requirements. Please also state the forecasted capacity contributions of resources that will be direct assigned to New Mexico jurisdictional customers to meet SPS's RPS requirement of 50% renewable energy in 2030, and how that system capacity contribution has been considered in determining how much of Gaines capacity and energy SPS should allocate to its New Mexico jurisdictional customers. Could you read me the response, please? Just the first paragraph.
The response states there are no reductions in the assignment of system resources to New Mexico customers resulting from the capacity contributions of the direct assigned renewable resources that serve New Mexico jurisdictional customers to comply with New Mexico's RPS requirements. And then we provide a table of the winter 2029-2030 and summer 2020-30 estimated capacity contribution of resources directly assigned to New Mexico. And we conclude after that table, the Gaines County CTG project's capacity and energy will be allocated as a system resource. The direct assignment of RPS resources will not affect the allocation. I'm so sorry, Mr. Lee. I'm reading very quickly. I'll slow down.
Estimated capacity of contribution of resources directly assigned to New Mexico.
And then there's a table that I guess I could describe the table if the hearing examiners would like me to, or Ms. DeJour, you'd like me to, but after that table, the response states the Gaines County CTG project's capacity and energy will be allocated as a system resource. The direct assignment of RPS resources will not affect the allocation of the Gaines County CTG project.
Okay, and this is your verified response?
That is the response sponsored by me and Mr. Gable, correct?
I move to admit Sierra Club Exhibit 2.
Any objection to what's been identified as Sierra Club Exhibit 2, an SPS response to discovery as verified by Ms. Lees? Hearing no
objection.
Objection, Sierra Club Exhibit 2 is admitted.
Oh, that was easy. Thank you. I am going to conclude. I'm going to go ahead and conclude with that. And I just want to give you a heads up that I would like to move my time remaining from other witnesses to Mr. Teisling. And if you could tell me how much time that leaves me, I would appreciate it.
Okay, so you reserved 15 minutes for Ms. Lees. You used 22 minutes, so you're -7. Oh.
I think I could do the math. Thank you, hearing examiner.
Okay. Yeah, it looks like around 30 or so. Yeah, that's just my quick thought there. Okay, great. Looks like the next questioner, I believe, Mr. Harris, you reserved 15 minutes for Ms. Lees.
Yes, Madam Hearing Examiner, in anticipation that a lot of the questions I had would be asked, and they have. Nonetheless, I do have a few I'd like to ask Ms. Lees.
Go ahead, please.
Earlier today, and I realize it's been a long day, the first of many, but earlier today you were questioned by Nick Soffit about the renewable portfolio resources. Do you remember that?
I remember Mr. Stoffel asking me questions about the portfolio, yes.
So just I'll cut to the ultimate question. Is it possible that there is a lower cost, more optimized preferred portfolio that could meet the RPS and other system needs?
No, sir, not in the under the RFP that we issued, and Mr. Gable can discuss that in more detail about what our options are.
Okay. Could you turn to page 11, please, of
In-
your direct testimony?
Yes.
And at line 14, you discuss how tax law and tax policy have an impact on your planning process. Do you agree with that?
My testimony, starting at page 14, through the next page on line 7, talks about how the passage of HR1 creates a limited window to capture tax benefits from renewable energy resources.
And just a correction, that's page 11, correct? Line 14?
So that's correct. Sorry. Page 11, line 14 through page 12, line 7.
So would you agree there's a bit of a deadline there to get these resources built before these tax benefits are no longer exist?
I agree. There is a lot of pressure on the timing of bringing on these resources in order to capture those tax advantages for customers.
Now, earlier you testified that you're not a modeling expert, but you're familiar with the modeling that SPS did for this application. Is that correct?
Mr. Harris, I'm familiar with the modeling that SPS did to select the portfolio in this application at a very high level, yes.
Do you know if SPS ran any models as part of its 2024 IRP or its RFP process to evaluate whether the optimal portfolio would be any different if projects were not able to come online in time to capture the tax credits we just discussed?
I believe the passage of HR1 happened after the IRP was filed. So I don't believe that that bill would have been modeled in the IRP, Mr. Harris.
Is that something that would be important to strengthening your application here?
I don't think so, Mr. Harris. The portfolio of resources are the most cost-effective, reliable portfolio to meet SPS system needs. The passage of HR1 just puts time pressure on being able to capture those tax benefits for customers.
Now, I'm certainly no tax expert, and I don't know how much you know about tax and taxation. If the projects didn't come online in time for these tax credits, would you be able to characterize the amount of difference it might make in the overall cost?
I cannot, Mr. Harris. I don't know.
Okay. Now, could we turn to page 24, please?
Okay.
And you discussed Dr. Teisling's testimony, and I'm only going to ask for some high-level answers to some high-level questions. We'll get to Dr. Teisling when he takes a stand. But how would you explain the economic analysis conducted by Dr. Teisling? How should it be viewed in relation to the total project cost and ratepayer impacts discussed by other company witnesses?
I can't answer questions about the analysis that Mr. Teisling did. He'll have to answer those questions, but the analysis shows the economic development benefits of these projects doesn't go to the costs of the projects themselves.
But you're aware that he forecast a roughly 47% rate increase for residential ratepayers. Do you remember that in his testimony?
I don't. You can point me to it.
I believe it's, let's see. Are you willing to discuss it subject to check? And it may have been a different witness, but I think you're a sponsor. Are you a sponsor of, let me rephrase. You introduce a lot of the more specific testimony that your colleagues make. Is that not correct?
Objection.
What's your objection, Mr. Larson?
The question is vague. We appear to be going beyond the scope of Ms. Lee's testimony. It sounds to me like we're about to ask her questions about Mr. Teisling's analysis, and I don't think the question is appropriate.
May I respond?
You don't have to respond because she doesn't start testifying, I don't think, till like page 16, because she's introducing every other witness. She has a table in her testimony about all the other witnesses' testimony. So I'm going to overrule your objection and let her answer the question. Ms. Lees, the question was, you introduce a lot more of specific testimony that your colleagues make. Didn't you? So answer the question.
My direct testimony does provide a roadmap for readers of what is in the application and what witnesses discuss in the application, and in part that is so folks can reference that part of the testimony to find the correct witness to address certain issues.
And you agree that the testimony in this case is rather voluminous, do you not?
I don't disagree with that.
Do you have any recollection whatsoever about what the rate impact might be if the CCN is approved?
Mr. Trowbridge provides a rate impact in his testimony. Yes, sir.
Could you quantify that, please?
I don't remember the exact quantification of that bill impact analysis. I'd have to look at it.
Hold on, Mr. Harris. Why don't you look at page 36 of Mr. Trowbridge's testimony?
If you can give me just a moment to pull that up.
Okay. Look at lines 2 and 3.
And I'm sorry, Madam Hearing Examiner, what page was it again?
Bottom of the page 36.
I'm at page 36. Thank you.
Okay. Does it help you quantify if you look at the answer beginning on lines 2 and 3 to the question, what's the proposed impact on residential ratepayers?
Yes, Mr. Trowbridge provides testimony on that.
And what's the quantification?
Mr. Trowbridge's testimony says, based on current modeling, SPS expects residential bills to increase by approximately 47.05% by the time all of the self-build projects are in service in 2030.
Thanks.
And he has more to that answer, but that's the
Sure.
first sentence. Yeah.
Go ahead. Go ahead, Mr. Harris.
Thank you. I'd like to move on to load growth now, and that would be page 34 of your testimony, Ms. Lees, your direct testimony.
I'm there, Mr. Harris.
And you testify to a 43% increase in forecasted load. Do you agree with that?
Correct. My testimony states, starting on line 6, as Mr. Goodeneff explains in his direct testimony, SPS projects that its peak system demand will rise from 4,504 megawatts in 2025 to 6,446 megawatts in 2030, a 43% increase.
Can you tell us, does SBS have an obligation to serve all this load?
SPS does have an obligation to serve.
Does it have an obligation to serve it on the timeline that a particular customer demands? For example, by 2030, regardless of the impact on, well, I'll stop there. That's a question.
Mr. Harris, we're already not serving load on the timeline that our customers desire. There have been customers, and much of the load that this resource portfolio will connect has been waiting for quite some time to interconnect. We have an obligation to plan our system to meet our system needs, including needs of our customers.
Do you analyze what the backlog of connection the impact it might have on other ratepayers or ratepayer classes?
I am
Sorry.
not aware of an analysis on the backlog.
Okay, could you turn to page 36 of your direct testimony?
Yes, sir.
And here we're talking about the SPP, the Southwest Power Pool requirements.
Yes, I start discussing the Southwest Power Pool PRM requirements on line 13 of page 36.
Are you aware of any efforts or engagement your employer SPS has undertaken as a stakeholder and member of SPP to improve the reserve margin and capacity accreditation process?
You'll have to ask Mr. Cooley and Mr. Gable about any efforts of that kind. I'm aware that we have quite a bit of engagement in the SPP, but they'll be able to answer questions specific to what that engagement has been to those specific issues.
Thank you. Do you know if SPS, and now we're looking forward, does SPS have any plans to study whether continued participation in SPP is in the best interest of ratepayers if the reserve margin is expected to continue to go up?
SPS, under the stipulation and final order in case number 13-00031, is required to make a filing in July of 2028 regarding its continued participation in the SPP and include a cost-benefit analysis of such continued participation at that time. And we plan to make that compliance filing.
Thank you. And you testified earlier that the planning process for this application started about a year before the filing. Do you remember that?
I don't remember that specific testimony, but the planning process for this filing, in my opinion, began in 2023 when we began the stakeholder engagement process for the 2023 IRP.
And so with roughly 2 years of time to plan, you still felt the need to ask for an expedited consideration of this application?
Yes, sir.
Thank you. I have no further questions.
Right on the money. Mr. Harris? I believe that our last questioner is staff, and staff reserved 90 minutes. Is that correct, Ms. Lang and Ms. Amer?
Yes, and I will be asking questions of Miss Lees, and I would like to not have it take 90 minutes, but it might.
Okay, so it might. So then let's hold. And I believe at this time, just to remind parties, we will begin again in the morning at 9, and we will go till shortly before 10, and then we will recess for the commission's meeting with regard to the new docketing system. So with that in mind, Commissioner O'Connell, do you have any questions, sir, for Ms. Lees?
Yes, I do.
Go ahead, sir.
Good afternoon, Ms. Lees.
Good afternoon, Commissioner O'Connell.
So first thing I just wanted to explore, and it came up a little bit earlier today, is the exception from the law and why SPS is asking for it now. One thing that struck me when I was reading it is the application is very much rooted in the conditions as they sit right now. Load growth, but the load that's coming is data centers and commercial and industrial load. There's limited import capacity from SPP into the region, the current planning reserve margin, the current capacity accreditation at SPP. So I was just wondering, thinking about testimony for today, but what the situation is going to be like in 2045. So first question is, does SPS think there will be any improvement in SPP's system generally? And then specifically, what is the new consolidated planning process expected to do?
Commissioner O'Connell, just respectfully, I think SPS witness Cooley is probably the better witness to talk about improvements to the consolidated planning process. I don't know the answer to that question. And okay, sorry, excuse me, sir. Go ahead.
No, please finish your answer.
Oh, in terms of improvements to the SPP system, again, I think Mr. Cooley might be a better witness to ask that question, but certainly I think the approval of the Gaines generation plant and the associated transmission that goes along with it, my understanding is that will improve the reliability of SPS's system in its service territory as part of the SPP. But I don't know if that answers your question. It might be better for Mr. Cooley to answer questions about improved processes at SPP.
I mean, the reason I'm asking you these questions is because you are who's asking for the exemption.
I agree, sir. The company is asking for the exceptions.
Yeah, the company's asking for the exception,
Yeah.
but you've been offered as the witness justifying the exception. So
Yeah.
that's why I'm trying to probe, since you're offered as the expert on why an exception is needed, how much consideration went into how different will the world be in 2045?
I think my testimony Commissioner O'Connell definitely discusses that the world might be different and that SPS will keep working towards 2045 compliance. One of the three options that I laid out in my rebuttal testimony was an exception at this time, but a future check-in on available alternatives for these gas plants and compliance with that 2045 requirement and whether an exception is still needed at that time. So I certainly think we are taking future compliance and future changes into consideration and making these requests, sir.
Well, interesting concept. The exception is tied to a request to certify capacity and give it rate-based treatment for a facility that depreciation schedule's 40 years. Testimony is it should last maybe up to 60 years. So what does a check-in mean?
My rebuttal testimony provides that should the commission approve that option, it would approve an exception, but order SPS to come in ahead of that January 1st, 2045 deadline with any alternatives available for the technologies at the gains and Tolk stations, or alternatives for how those units are being treated, whether we accelerate depreciation on those units or not. But bring forward those proposals, whether there's a technology available for conversion or carbon capture or something else, and make the determination at that time whether any of those alternatives are in the public interest or whether the exception is still in public interest in order to maintain system reliability and in order to prevent undue impact to customer bills at that time.
Yeah, well, thank you. You segued to my next question. Looking at SPS's testimony and just based on my experience, the revenue requirements of a rate-based asset are the highest the first year of inclusion in rates. Would you agree with that?
I agree with that, sir.
So rate basing an asset and getting rate base accounting treatment means that the first 10, 15 years of recovery of the cost of that asset will be the most expensive. Would you agree with that?
I agree with that, sir. And Mr. Fisher could probably talk in more detail about how that works from an accounting perspective. But yes, I agree with that, sir.
Yeah, again, I'm asking from just commissioner concept of asking me to bend the law. And so why would I want to do that now? And it looks like the cost is front loaded. I'm trying to understand the future implications again, like does SPS believe that the integrated transmission planning process will create a situation where there'll be more import capacity into SPS's region?
So certainly, Commissioner, the Renewable Energy Act requires that the commission ensure system reliability and prevent undue impact to customer bills as it effectuates the act. And SPS brought forward options for the commission in order to do that with this portfolio. And I think that my testimony, Mr. Gable's testimony, Mr. Trowbridge's testimony really demonstrate how rejecting these gas resources today create reliability issues and undue impact to customer bills issues today and in 2045. And as you know, planning for the system is a long-term process, and we can do the best we can under the conditions as they currently stand. We have a need today, and this portfolio does address that need. It addresses the load growth need that we have on our system. It addresses the pending PRM requirements that we must meet. and it addresses replacing the Tolk coal plant. And recognizing that the commission has that responsibility to maintain reliable service and to prevent undue impact to customer bills when effectuating the REA. I believe the commission or the company has brought forward pathways for the commission to do that by bringing forward exceptions. Certainly, if the commission doesn't feel that exceptions are warranted at this time, they can still approve the CCN and address possible exceptions in the future.
And so I appreciate you offered options. All of those options are predicated on rate-based accounting treatment. Is that correct?
Those options include recovering the cost of these resources. Yes, sir. And putting them
My
into
question
rate
is a little more
base.
specific than that.
Yeah, and putting them into rate base.
They assume cost recovery using a rate-based depreciation schedule.
That's correct, sir.
Okay. Then just going down the laundry list, does SPS believe that SPP's planning reserve margins will never change?
I don't know whether SPP's planning reserve margins will ever change or not, sir. I certainly know
How about their capacity accreditation?
I don't know if that will change, sir. I certainly know that it's under discussion still at the SPP.
Is SPS in this case committing to do anything to try to make the situation better at SPP?
SPS, Mr. Cooley and Mr. Gable both are active in the SPP and are active in these conversations, sir, and will continue to advocate on behalf of our customers and our company. I guess they can talk more specifically on what that looks like from their perspective, but
Yeah, again, just asking you, Ms. Lees, as the witness, asking for the exception, whether SPS has considered that the situation might improve at SPP, or as a influential member in member-driven SPP, is SPS trying to improve the situation so these options that you've offered have some meaning?
yeah, I certainly think that SPS and its representatives that go to the SPP will continue to advocate on behalf of the company and its customers. And Commissioner O'Connell, I'm sorry, in my position as regional vice president, I don't participate in those committee discussions or those discussions at the SPP. That is Mr. Cooley, which is why I'm kind of a little uncomfortable answering questions regarding the specifics of how that works. But I do know that we'll continue to advocate on behalf of the company and our customers.
Yeah, I appreciate that. I'm just saying, as the witness who's got the exception in her testimony, just wondering, how much analysis or thought went into how absolutely needed is this exception?
I think it is needed, and Mr. Gable can go over the analysis that he did for the exceptions regarding what the impact is to reliability and what the impact is on. Mr. Trowbridge can talk about the customer bill impact of that. But today we have the need, and today we have to meet that PRM requirement. Today we're seeking to replace the Tolk coal plant. And so the company is bringing forward a portfolio, most reliable, cost-effective portfolio that it can bring forward to meet those needs today through 2031. And they also help us meet our needs through the rest of the planning period in the IRP.
So has SPS requested any exceptions from SPP?
Exceptions to what, sir? I'm sorry, to the PRM?
Well, to any of these binding constraints that lead to the portfolio that has been designed and requires asking me for an exception.
I'm not aware of whether we've asked for an exception. I think Mr. Cooley can probably speak to that. I'm not familiar enough with the procedure at the SPP that would allow for us to ask for such an exception.
Again, I'm not just in my mind as the witness who asked for something. I try to make sure I know what I've set myself up for when I make the ask. So that's what I was assuming had happened behind the scenes. So apologies for impertinent questions, but again, your testimony is where this exception lies. So I'm trying to understand, and it's strong on we have to have an exception now for an event that is decades away. So trying to understand the need for the ask. So then just moving on, and this is a bit of a follow-up from some questions that Mr. Stoffel had asked earlier, but you give us the map for the very many witnesses in this testimony. Which witness addresses how SPS will directly assign the benefits for the resources that are assigned directly to New Mexico jurisdiction?
In terms of the treatment of federal tax credits and those benefits, Mr. Cunningham addresses that in his testimony, but go ahead. Sorry, maybe I'm misunderstanding what you mean by benefits.
Well, to me, benefits is more broad than tax credits, right? SPP operates an integrated marketplace. So if you've got a solar plant that's direct assigned to New Mexico and that SPS is selling electricity from beyond its footprint into that marketplace, how is SPS going to ensure that the customers who are paying for that resource get the value of that revenue? And I was looking for a witness that would address that, and all I saw was witnesses talking about must direct assign the cost. Didn't see any witness talking about we will also direct assign the benefit. So hoping I missed it.
I generally testify, sir, that any resources selected only for RPS compliance, the benefits of those resources are the RECs generated by the resources, and New Mexico enjoys the full benefit of those resources. But for the requirement, those resources would not have been selected. Mr. Cunningham talks about, as I said before, how federal tax benefits will flow through the customers. In terms of market discussions and how these resources will be treated from a system planning perspective, Mr. Gable is the witness for that.
Yeah, again, those like Mr. Gable's planning witness, I was just looking for somebody to explain the mechanics of when excess is sold into the integrated marketplace, how that money flows back to the customers who paid for that resource.
I believe Mr. Cunningham or Mr. Trowbridge can discuss that.
But okay. And then I struggle with how to ask these questions because apologize, an engineer, so I'm not trying to be accusatory or anything, but when you were talking to Mr. Stoffel, you talked about there was certain things that would cause SPS to reevaluate its self-build projects. is there a list of those things?
I believe in my rebuttal testimony, I identify a few things that would cause reevaluation, one of which is finding by the commission that we would not be able to recover the cost of resources approved past December 31st, 2044. The other finding that would cause us to reevaluate resources is if there was a performance incentive mechanism required for any of the resources.
Okay.
Those are the two I can remember discussing with Mr. Stoffel.
Another one that I'd like to get the company's position on is several of the witnesses that are involved in the self-build projects offer that SPS has robust construction project management system. And that's why we should feel assured that the price will be reasonable. Would SPS sharing those project management reports as the projects progress with the commission so we can see early on if things are going south in terms of cost or in-service deadline, would that be a reason to reevaluate self-build projects?
I'm sorry, Commissioner, and I'm just trying to understand the question. What did you asking if?
Well, for example, your SPS witness Morrison talks about very robust construction project management within the company. What I'm asking for is, would SPS object to transparency into that process? So as these, $9.5 billion worth of projects move through the pipeline, we can see, are they progressing reasonably or not?
I'm certainly open to talking about a way in which we can keep the commission informed on the progression of construction of these projects.
I'm
Yeah.
asking if the commission ordered something, would that have an impact on SPS's plan to self-build projects?
If the commission were to order us to report on the status of construction of these projects, I don't believe just providing updates and transparency into how that's going would per se cause us to reconsider building the projects.
And then there were questions about thinking about rate impacts across the whole portfolio, not just the tranche that's in this filing. There's a total of like 3, I think. Has SPS quantified rate impacts of this plus the $3.5 billion transmission line?
Are you referring to the 765 transmission line?
Yeah,
Oh, okay. I'm not aware at this time that SPS has done a bill impact for the final preferred portfolio, in this case, plus that 765 kV line. I'm not aware of that, sir.
And then I believe there's more transmission in the integrated transmission plans than just that one line that might impact bills for New Mexico customers, as SPS tried to provide a full picture of everything that's going on right now.
From a bill impact perspective, we've focused on the bill impacts of this portfolio. Sir, we haven't included any possible future transmission being considered at the SPP at this time.
Yeah, I didn't believe those lines were considered. I thought they'd been approved.
They could have. Mr. Cooley is more familiar with the status of those at this time than I am.
Okay. Appreciate that. That's all my questions.
Thank you, Commissioner.
Thank you. Commissioner O'Connell?
Hearing examiner, if it's a good time or if you were going to break, that's fine. But I was just going to note that I could ask my questions now if
Yes, sir.
it's a good time.
Please, Mr. Chairman, go ahead.
Okay, thank you. Hi, Ms. Lees.
Hi, Chairman Aguilera.
I have the honor of speaking to you after a long day.
The honor is mine, sir.
So I like Commissioner O'Connell, I also am trying to understand the requested exceptions with respect to the zero carbon. And in your testimony, you explain, for example, in pages, I think it's, sorry, find the right place. Scrolled. Okay, so on page 72, for example, you say in this section of my testimony, I discuss the potential need for exceptions under the REA for compliance with the 2045 100% zero carbon resource standard and request that the commission grant SPS an exception to the 2045 requirement in the event that the commission deems one necessary. And so don't want to read into this without your clarification here, but the next sentence starts with the words again, to the extent necessary. And then on page 45, you ask and answer the question, does SPS require an exception to the 2045 zero carbon standard requirement at this time? And in your answer, you start off with potentially. So just kind of reading, if necessary, to the extent necessary, potentially, how, and maybe, am I understanding correctly that you are requesting the exceptions if the commission needs that to approve the CTGs?
Yes, Chairman. So the reason that my testimony positions these requests in that manner is because these resources and the CTGs specifically are needed to meet system needs today. But we recognize that there's a 2045 requirement, a zero carbon requirement in the future that the commission must consider. And that precedent, EPE's former case, I can't remember the case number off the top of my head, but it's in rebuttal. EPE had been criticized for bringing forward an emitting resource without providing consideration or pathways for the commission regarding that 2045 compliance. So SPS brought forward the exception requests. We believe that we qualify for those requests under section 6216.4 and the requirements that the commission in administering the standards maintain system reliability and safety in administering those standards and prevent undue impact to customer bills. And so to the extent that the commission feels that an exception is necessary today in order to approve emitting resources, and the exception is needed today because of that 2045 requirement, we've put forward the evidence showing that those exceptions are warranted today and in 2045. Our intention is to put forward options for the commission so that it can approve these resources. They are needed today, and they're needed for system reliability. They're needed to serve growth. And we wanted to make sure that the commission understood that there are options available to it in order to grant the CCN. My rebuttal testimony goes through those options. The commission doesn't think that exceptions today are necessary. One of the options is just to grant a CCN. The other option is to grant a CCN with the exceptions. And the third option that I put in front of the commission is to grant the CCN with the exceptions and require SPS to come in at a future date with possible alternatives for these units in consideration of the 2045 requirement.
In the statute 6216 for B2 and 3, those are the ones that you highlight in your testimony. B2, well, I'll read 6214B first. It says, in administering the standards required by paragraphs 5 and 6 of subsection A of this section, the commission shall. And then 2 says, maintain and protect the safety, reliable operation, and balancing of loads and resources on the electric system. 3 says, prevent unreasonable impacts to customer electricity bills, taking into consideration the economic and environmental cost and benefits of renewable energy resources and zero carbon resources. And so I think what the argument is in the application testimonies provided by SPS is that the CTGs are needed for reliability and to prevent unreasonable impacts to customer electricity bills. And well, am I understanding that correctly? Would you modify that?
No, sir, that's correct. And Mr. Gable provides modeling to demonstrate the reliability impacts of not approving Gaines and Tolk CTGs today. And Mr. Trowbridge also provides the analysis of what the impact to customer bills would be should those units not be approved, and SPS would have to plan for replacement resources for those units for New Mexico.
Yes, and I think where I struggle to find the balance is that the resources come with an enormous price tag. I think if I'm correct here, it's, for Gaines and Tolk, it's 2.7 billion plus 2.2 billion. That's only to build the plants. That's not even considering the fuel that is needed to run them. And so how do I balance right now the impacts on the bill, given that there's such a huge investment to potentially avoid huge investments? And so that's one thing that I'm struggling with. And the other is that there is a large portfolio of projects that SPS would like to build. And here we only have 8 of those. And that's not providing the information right now to sort of evaluate the reliability claim. I think the other thing that makes it difficult to evaluate that is that we don't actually know what the load is going to be in 2045. Certainly have more certainty about what load requirements are now. But in 2045, it starts to get even more difficult to evaluate whether this is needed for reliability or not. And so, you know, I wanted to note that, you know, just also trying to make sure that I understand, and I do see your options in the rebuttal testimony as well. Just trying to make sure that I'm understanding the request accurately.
Chairman Aguilar, and I apologize. I'm not sure if there's a question in there, but it was it was long, but I want to be helpful and to point you maybe to some witnesses who I think can really discuss in detail the modeling around reliability requirements today, and what denial of these resources mean in terms of reliability and our ability to maintain system reliability and serve load. And not just load growth, but load currently on the system today. And Mr. Gable can really provide in-depth testimony on that, because his testimony provides that analysis for the exceptions, provides that evidence for the exceptions. And then in terms of load growth and how we consider load growth in the outer year, what I'll call the outer years in 2045, Mr. Goodenough is the witness that can kind of speak to how we model for that load growth, what is taken into consideration when looking that far out. But what I will say is we have a confluence of factors here that are driving the need for these resources. We need to replace the Tolk coal plant. We have load growth, but we also have increasing reliability requirements that have been set by the SPP and approved by the Regional State Committee at the SPP. So those are our requirements today. And looking into the future, it is my opinion that Mr. Gable has provided the evidence that shows that the resources we're bringing forward today are the most cost-effective and reliable resources among available options in the RFP, and that they continue to meet the need and contribute to meeting the need on our system out into those outer years as well.
Yeah, thank you. And I do intend to, I do have questions for them as well. I was referencing that for you with respect to the exceptions that are being requested. And so there's kind of a bridge there between the reliability and the cost impact, the exception. So I recognize the confluence of needs, anticipated changes that are coming with retirements. I understand that the average age of your fleet is over 40 years, and you have maybe like 10 resources retiring by 2028. I also understand the need, the requests that you have from customers and the PRM requirements that SPP has adopted. There is a lot going on there, and just trying to make sure that I understand this from the correct perspective. And so let me just take a quick look at my notes here. And maybe these are just kind of heads up also for other witnesses. But who can I ask about? So there are these surplus solar resources. Who can I ask about how those resources can and are intended to be bid into the market?
Um, um, Mr. Lytle, I believe, is the witness discussing the solar resources, and he can discuss how they'll be operated on the system.
Okay, thank you. And do the testimonies talking about the entire application somewhere provide an explanation of the levelized cost of energy? I know Mr. Gable, sorry, provides some information there, and I'm not seeing in there, but what I'm trying to identify is what the true costs to ratepayers will be in the long term. So I understand from the Gable testimony that for renewables, SPP considered the levelized cost of energy for battery and the CTGs. I'm sorry, not SPP, SPS, Excel. And Excel considered the levelized cost of capacity. Earlier, Mr. Rodriguez, in response to a final question, said that he was not aware of renewables that could be cheaper than the gas units. And I think you can definitely come to that conclusion when you only compare the upfront cost of building the projects. I want to see the levelized cost, the true cost of these projects. And is that somewhere in the testimonies?
I believe it's provided by Mr. Gable, but if it's not there, then I'll have to take a look and see if we provide it elsewhere.
Okay. So maybe that's a heads up to
Okay.
Mr. Gable. So one of the things you talk about in your rebuttal is with respect to the combined cycle plants, and let me know if I am mischaracterizing, but what I'm seeing here is a story where SPS is proposing some combustion turbine generators, simple cycle, and some of the interveners are asking, well, why are you not building a combined cycle plant? Which I think are more efficient, right? And more expensive to build, more efficient in terms of the fuel that is consumed to generate. And I see the response here as being, well, we didn't get any bids for combined cycle generation, so we couldn't pick any of those. And also, we need to build them now. We could potentially face penalties from SPP if we don't meet the PRM. And so I find that a little unsatisfying, well, not a little. I find that unsatisfying because we're talking about almost $5 billion worth of investments. And to say, well, we didn't get any of those bids, that's a big investment, right? To not do another check potentially. I don't know, not that I'm suggesting that, but I just that's just my reaction. So there's not necessarily a question for you there, but just an opportunity to respond to that if you have a response.
So there's many factors I think that the company takes into consideration when developing bids, including ability to construct, federal law and requirements. Mr. Gertz, I think I've testified, can testify to and talk about why the company decided to bid in what it did. What I will say is that the commission has a process that we need to follow in order to bring forward a portfolio. And that's develop an RFP after you have an accepted IRP, work with the IM to go through a bid selection process that results in the most reliable and cost-effective portfolio among available projects. And in that bid selection process, we conducted that fairly. The IM filed their final report and said that was conducted fairly and transparently. I don't know that going back and saying, we want a bid, we're going to delay this process, we want a bid to look at for a CC would have been fair or transparent. But what we did receive was an informational bid on the cost and of a potential CC. And while that bid wasn't actionable because it was informational, it didn't meet the requirements in the RFP. And Mr. Gable can testify more to what he could and could not model in bid selection. What that informational bid did tell us was that it wouldn't have been the most cost-effective resource to select. And I think Mr. Gable can talk about that a little bit in more detail.
Yeah. Okay, thank you. Just looking at my notes real quick, making sure I don't have anything else. I think that's it for me.
Chairman Aguilera, I have one more thought for you on your concerns about evaluating the exceptions now, if you would let me provide it.
Yes, please do.
Okay. We talked a lot about how there are needs on our system today, and that we're planning for those needs today. What I will say, and the evidence that Mr. Gable puts forward in terms of modeling what the system would look like if we got denial of gains, does concern me in terms of heading in a direction where we're starting to have to split SPS's system today and plan for a New Mexico system and a Texas system. My opinion that doing system planning is in the best interest of our customers. It's the most efficient way to plan for the system. And I think that the evidence that Mr. Gable puts forward shows some of the consequences of that. And I have a lot of concern about the cost consequences of having to split the system today based on a denial of gains in tolk, on what those cost consequences would be for New Mexico customers. And I think that's also something that the commission should be taking into consideration when it makes these policy decisions on whether or not the exceptions are warranted.
Sure. Under one of your options, you talk about the potential to approve the plant without making a finding as to the exceptions.
Yes, I think
Yeah.
that is an option for the commission to grant the CCN without any exceptions.
Sure. And I'm not, I'm kind of separating the question, the evaluation here right now, just to well, I talked about both, but with respect to this issue, just to the evaluation of the statute and the exceptions being requested.
Mhm.
I guess as you mentioned, your additional comment, it made me think of one other question that I wanted to ask. Just to get your thoughts and maybe also to make sure that I'm understanding this correctly. And in your testimony, you reference additional testimony, the methane analysis that shows a qualification of 363 megawatts, I think it was.
That sounds about right. Yep.
And when I saw that, one question that came to my mind was should 363 megawatts qualify a 1 gigawatt plant? Again, recognizing that's not your testimony, you referenced it in there. But it seems like could be bad precedent there. It could be a loophole potentially if a small, a third, let's say a third, let's call it a third of a plant were to qualify, then the whole plant is found to be reliable, as opposed to potentially proposing a 363 megawatt CTG.
So
Yeah, no question for you there, but again,
Yeah.
opportunity to respond.
So our request is not to qualify the entire plant, but to qualify that 363 megawatts as being designated zero carbon, recognizing that should the commission approve the CCNs and decide to designate that quantity of megawatts as zero carbon, that really brings benefits to customers, because what it means is in order to get to the 2045 requirement, we already have that 363 megawatts counting towards the zero carbon requirement because of the amount of methane reductions it enables. And the utility doesn't need to build additional resources by the magnitude of 363 megawatts in this example in order to meet that requirement. So we feel like it's an additional pathway for the commission, certainly with these resources, and that it provides customer benefits.
Yeah, and that argument makes sense in terms of how it would qualify in with respect to the RPS or zero carbon standard. But what I'm thinking about is the practical effect it would have on constructing the facility or not. So kind of going to the phrasing that I started with, to the extent the commission deems it necessary to grant the exceptions, then whether the commission would consider treating those 363 megawatts as zero carbon or not could have a bearing on whether the facility is constructed at all. And so that's it's more the practical effect that I was thinking about of where I said, could that be a loophole?
I okay. I understand what your concern is. I think the company has said what would make it reconsider constructing these resources is if we get a finding on cost recovery past 2045 of these resources. And certainly if the commission makes such a finding on that, it would cause us to reconsider whether we need to construct these for New Mexico.
Yes, thank you. I did see that in your testimony. I think that's all I had.
Okay.
So thank you for your time.
Thank you, Chairman.
Thank you, Mr. Chairman. Ms. Lees, I just have one observation and or question with regard to the chairman's question and then your late added response to him about more of a what I consider to be basically the policymakers in New Mexico need to think about the policies that they are implementing. And I just wonder if that's the same recommendation that you make to the policymakers in Texas.
Certainly, Commissioner Hurst, the issues in Texas are different.
Not a commissioner.
Oh, excuse me.
Lowly hearing examiner.
Switching from commissioner to hearing examiner. Certainly, hearing examiner, the issues in Texas and the policy issues are very different. But I think, of course, each jurisdiction needs to consider the implications of the policy decisions they make on the utilities they regulate, the legislature and the commission itself in both New Mexico and Texas.
Don't you think that since New Mexico already has another multi-jurisdictional, and I guess we could even say that to a certain extent, there's more than two, but at least when considering SPS and EPE, they both operate in Texas, right?
That's correct.
So don't you think that the commission, while considering regulating its own citizens, don't you think that they consider potentially the effects that the policies they have extend beyond the borders of New Mexico?
I don't know whether I can't speak to whether policymakers in New Mexico consider how those decisions extend beyond the borders, but I certainly think that policy decision makers in New Mexico consider what the implications of those decisions are to New Mexicans.
Well, you specifically were referring to the chair with regard to what I heard in your response to be the increasing difficulty of having resources that may be approved and or qualify with the laws of one state but not another, and then it's becoming increasingly difficult for SPS, right?
That is certainly, if we get denials of the Tolkien gains units, in this case, it will be very difficult for SPS. We'd have to take denials of emitting resources into consideration as we continue to plan the system.
Well, and do you share the same difficulty analysis with resources that have been approved here in New Mexico but denied in Texas.
Yes, ma'am. We share that as Texas denies resources for various reasons, that planning the Texas and New Mexico systems separately and not as one system, that becomes more and more inevitable, and that we don't believe that's in the interest of our customers.
Okay, so the blame's just not being put here in New Mexico. You're sharing it.
Ma'am, I don't want anyone to think that I'm blaming New Mexico. I'm talking about the difficulty if these resources are denied and we need to start planning New Mexico system separate from a Texas system rather than a system as a whole, that I have serious concerns on the impacts to customers and the cost implications of those impacts.
If you know, are there any similar situations in either of Excel's other public utilities that they face the same or similar difficulties?
Certainly, some of the other OPCOs serve multiple jurisdictions, but I'm not as familiar with how those difficulties or whether there are difficulties playing out in those jurisdictions and whether they rise to the magnitude of challenges we have here when facing the possibility of getting denials of resources, system resources, and needing to look at planning for two systems rather than one.
Okay, thank you. I appreciate that, Ms. Lees.
Thank you, Madam Hearing Examiner.
So I think with the lateness of the hour, Ms. Amer, I think you got preempted by commissioner questions, and you can ask your questions in the morning beginning at 9 o'clock. Before we go, Ms. Lees, I would like to see your ZEL-2 exhibit filed in case number 25-00079, the rate case. It is not in InfoShare. And so while I can still get on InfoShare, if you could make that available. I do not see it referenced in your testimony in that case that it is confidential, but you can tell me about that. I'd also, Mr. Larson, this is going to be a potential bench request number 3, and that's going to be identify and quantify how direct assign project benefits are signed. So I think Ms. Lee's thought in answer to Commissioner O'Connell's question that Mr. Cunningham or Mr. Trowbridge might be able to do that. I'm just putting you on notice. If I don't get a complete picture to that, then you can consider this to be a bench request. Also, just in planning for tomorrow, it appears, I don't know that we'll get finished with Ms. Lee's before the 10 o'clock break, but after we conclude Ms. Lee's testimony, it looks like, according to my list, we would go on to Mr. Gable. And then I believe we were notified yesterday, Mr. Lytle has a conflict, and now we need to move him, I think, around Mr. Cunningham. So the end of the SPS witnesses. So with that, we would go to Mr. Gable, and then I believe Mr. Gertz. And then if we have time, it looks like the next 3 are Fowler, Parks, and Asmus. So that's kind of the an optimistic line up for tomorrow, knowing that we're going to break from 10 to 12 for the commission meeting on the docketing. And it looks like Miss Amer, I think you had your hand up.
Yes, that's correct. I just wanted to note that Commissioner O'Connell asked about certain pricing information, and attached to the confidential direct testimony of Mr. Zigich is an exhibit that contains the information that Commissioner O'Connell was seeking.
Okay, thank you.
And I believe that the commissioners have access to that.
They do. But thank you for referencing us, Miss Amer. Appreciate that. Mr. Larson, do you have your hand up too, sir?
I do. Thank you, Madam Hearing Examiner. And now I have to figure out how to lower it. Oh, okay. So with respect to the last potential bench request you were speaking about, there is some discussion about where the benefits, particularly associated with the Sandy Loan Project, pages 24 to 26 of Mr. Trowbridge's direct. That probably is not a comprehensive summary of it, but we could put some work into that and update you in the morning if that's helpful as well on other places where that's discussed.
Yeah, I think that if, to the extent that that doesn't quantify, identify and quantify all direct assignment project benefits, then you may have to update it. So you can take a look at that and see whether or not you think that that answers the question. Okay.
That sounds good. Thank you.
Okay, great. I don't, oh, Mr. Stoffel, I see your hand.
Yep, one process question about tomorrow. You mentioned breaking from 10 to noon for the new filing system. And then earlier today, you'd mentioned also breaking for lunch. I just wasn't sure. Are we planning to break in like 10 to 1 tomorrow or 10 to 12:30? Can you give us a sense of timing for when we'll reach?
Yeah, I'm kind of thinking, I don't know. I mean, I guess I was told that the meeting was going to be from 10 to 12. So, and Mr. Lee, I don't know that we need all this on the record. So I think we can just go off the record to talk about our process here. Thank you, sir. And I will, everybody should log in tomorrow at 10 till. But I thought it would be kind of mean if I didn't add a lunch break. If you'd been on the hearing, I mean, although, you're probably, whatever, you probably could eat, but no, I was kind of thinking it would be from like 10 to 12:45. It is what I was thinking.
Thank you.
I can think otherwise if people, want to talk about it tomorrow, but okay. Hearing Examiner Schaefer, anything I've forgotten to give the update for tomorrow?
No, I think we've covered everything.
Okay, great. Well, it just has us at 5:07. Excellent. All right. Well, maybe tomorrow the Dropbox will be working for us. I thank you all for your participation today, and we are recessed until 8:50 tomorrow morning. Thank you.
Thank you, everybody.